average. Also,
my lord, also there is another aspect to it.
We increase in a very linear fashion.
My lord, there is another aspect to it. In fact, NT has published several answer keys. My lord, I'd like to point. My lord, I'd like to. I'd also like to point out some.
May I say something? Only one of the 56
May I be able to
is a top
make a small submission, my lord?
The rest, all of them have been meritorious, have scored highest mark in class 10.
Doing of marks is so systemic that the whole examination is affected. Or is it possible to identify people who are wrongdoers or likely wrongdoers? In which case a retest can be held for those students only.
I'd like to make a small submission.
But I can assure your lordship about one thing. But we are not adversarial to the petitioners. Either way, the petitioners who have an apprehension somewhere else.
What we'd like to do, insofar as the petitioners are concerned, all lawyers for the petitioners, please, we'll take it up on Wednesday. Give them a day's time. Wednesday also wanted 1 day's time. We'll give you a day's time to put your together. We want all the lawyers for the petitioners who are asking for a retest, to sit together between now and Wednesday and give us one set of submission. And we can't. Counsel, as we do in the CB matters, you give us one consolidated submission, say not exceeding 10 pages. I don't mind, it shouldn't exceed 10 pages. Why you are asking for a retest? All right. Likewise, we'll do this. We will ask the government to circulate a comprehensive list of dates and a response to what we have raised.
CBI can be directed. Everything is with CBI.
As we have seen in the reply, they say we do not know whether it was systemic or not. Here sometimes they completely deny there is full leak. So let the CBI file a status report with this honorable court with all 6 FIRs that will place the picture in which direction the investigation is going. Not all 6.
Court has always open quayas. Nothing is concluded by us. We are just saying that it's infructuous. Item 4.
My lords, it will ultimately, the matter will ultimately be the Lordship's court only. So I'm just.
So it's always open quayas. We are saying it's disposed of as infructuous. It can never bind in a future bench.
I'm very grateful, my lords.
In this matter, admittedly, the NCLT finds that my claim and my allotment to the flat is reflected in the information memorandum, which is the basis of any resolution plan. And it is showing in the record.
What about delay?
Yes, my lords. On delay, my lords, admittedly, I am not present when this pronouncement is made. My lords, the matter is reserved 3 months back. It comes in a pronouncement, my lords. My appearance is not there. I have vehemently said that I was not present. It is uploaded, my lords, and
What is the date on which it is uploaded?
my lords, it is uploaded on 22nd of August 23, from which, my lords, I am within limitation, excluding the certified.
You were not present. Were you a party?
Yes, it was my application, my lords. On my application while reserving.
But then, if it's your application,
Yes, my lords.
then can you say that I was not present? I don't know because.
So, my lords, the arguments happened. The order stands reserved.
But it is.
Not-
when is the order pronounced? Actually, it's not pronounced at all.
Not on the dates argued, my lords, not on the dates heard. It comes up in the list 3 months after for pronouncement.
22nd August.
No, my lords, 11th of August. 22nd August is when it is uploaded and which is when I gain knowledge of the order. And I, my lords, file immediately. I file the appeal immediately.
Then counsel appearing on behalf of the appellant submits that that in the application which was filed by the appellant, though the order was passed by the National Company Law Tribunal on 11 August 2023.
Yes.
The order was uploaded only on 22 August 2023. Hence, it has been urged that the appeal which was filed on October 2023,
Lords, 10th October 23.
10 October 2023 would be within the period of limitation of
Lords, 61.
the limitation. We'll issue notice
grateful. Manoj, may I only make one request? The resolution plan basis which my application was dismissed even to date has not been approved by the NCLT. Now, Manoj, may I only request for an interim stay?
We'll make it returnable in 2 weeks.
Right.
Stay everything. Serve Dusty and come.
So good.
See, in this case, the NABARD, though initially it said that there may be certain irregularities in the functioning of the bank, subsequently it filed an affidavit before the High Court stating that the resolution of the board was proper and that there were no irregularities. Ultimately, this was a public interest litigation. You brought some grievance to the attention of the court. The court has felt that it is not necessary to interfere.
Page 368 may be seen for a moment.
What is that?
Ordered by High Court. Honorable High
The earlier High Court, the earlier order.
Yes, Lord. It says, Lord, pursuant to previous order, action taken, report on behalf of the NABARD has been placed on record. Prima facie, certain allegations were stated to be true.
But that is prima facie. Subsequently, NABARD files an affidavit and says that we have now looked at it and there's nothing.
Later, Lord,
Anyway, as a PIL petitioner, your duty was to point it out to the High Court. High Court went into it. NABARD is a National Bank for Rural Development. They file an affidavit. Now why should we?
but the error is page 389 may be seen, Lord. Uttar Bihar Gramin Bank, as well as not the sponsored bank, Central Bank of India was directed to take decision on this erroneous activity. That is my
But ultimately, as a bank, it is regulated by the state authorities, since it's a state bank, as well as to a certain extent by the Reserve Bank of India. We presume that they will not look into any regulatory failures in the bank.
Any fraud above 3 crores is directed to be investigated by CBI. But here the quantum is not above more than 500 crores. That is,
Sir Counsel, we are referring to the affidavit filed by NABARD dated 21st February 2024, where the averment is that it is humbly submitted that as per the specific directions dated 18th January 2024 of this court, the instances pointed out in the special audit report were scrutinized. On scrutiny, respondent number 4 is satisfied with the resolution of the board of UBGB that the guidelines of fraud are not applicable to the present matter, audit report, and therefore the matter is not required to be referred to local police / CBI as per clause 9.1 and 9.2 of respondent number 4.
So initially, not 13.
I think you made our point clear. I think we'll not entertain it further. It is a PIL after all. Yes, dismissed. Item 6. Item 6. Yes, Mr. Raghunath, you are on the screen.
Advocate Raghunath on behalf of
Filed a writ petition before the High Court for early hearing of your appeal before the DRAT. And now you are in the Supreme Court under 136. We're not going to entertain these kind of...
Your Honor, my lord, we test appeals against the order of the Honorable High Court, and there is no sunmai, there is no about 24 hearings have happened.
What do we do? The tribunals are... It's not that the tribunals don't have work. They have their own priority.
But my lord, it's a question of recovery of 208 crore rupees.
No, but you're postulating that your case is the most important to be reaching the line or the queue. Other cases may be as important before the tribunal. Why should we expedite your case? We'll not do anything like that. Thank you. Dismissed.
Well, this is a petition seeking appointment of an arbitrator. The clause of arbitration which finds place in the SPA was SHA, which was initially disputed by the other side, gradually accepted on an affidavit and recorded by the High Court in its order, saying that they were trying to mislead the court, but they've then accepted the existence of the SHA and the arbitration clause. We are only seeking appointment of an arbitrator because one of the respondents is a Sri Lankan citizen and the other is an Indian citizen. Both of them being shareholders in the company, which was created pursuant to the SHA.
Manoj, I'm appearing for the respondents here. Let them supply me a copy. I'll come back in 2 weeks and give my no objection for the appointments.
for the appointment of the arbitrator?
After perusing the agreement, because there was a confusion about the agreement per se, the notice of invocation says the arbitrator.
Fair enough. You are appearing for both the respondents, right? You are appearing for both the respondents.
Yes.
Fair enough.
They've admitted the existence
I
of
know.
the
He doesn't have a copy of the papers. He's on caveat. So
I'm not on caveat also. I'm just appearing.
Issue notice. Mr. Can I have your name?
Karthik Malhotra.
Mr. Karthik Malhotra, Parent Counsel appearing on behalf of the states that he has instructions to appear on behalf of the respondents, and seeks a short adjournment to take instructions. A copy of the paper book be supplied in the electronic form to the Parent Counsel for the respondents. List on. Should we keep it on Monday and finish it on Monday?
Please, my lords.
My lords, Friday.
All right, next Friday.
Next Friday.
Very well. Next.
Yeah. Item number 8, my lords. The candidate who was selected as the president of the Consumer Disputes Redressal Commission for Mallarkotla.
Sangrur.
For Sangrur. The candidate who was selected resigned.
Within 6 months.
Within 6 months. In which case, you are the second candidate. You have no vested right for appointment.
No,
if the candidate does not accept the appointment, then the second candidate can say that, well, appoint me to the. Once a candidate is appointed, then the select list comes to an end because the process is
Our
complete.
submission was only this, Lord, that the OM says that if a person joins and resigns or vacates within 1 year, then, my lord, the merit list has to follow. In this case, my lord, the OM is there and the judgment of my lordship, 3 judges of this court have said. And my lords, this is since no, that's right, my lord. But my contention is that since this is a judicial selection, instead of going through a fresh selection process, my lord, people can, and I'm there in the merit, my lord.
The government picked out all candidates who are lower in the list. That whole selection process in Punjab was replete with all kinds of
What they
difficulties.
have done is, in my district, Sangrur, after, my lord,
Because the Punjab government thought that they can just pick up candidates who, are, suitable to them, overlooking the select list.
So that's my case. When one resigned, they appointed someone who was not even in the list, who didn't even apply. I was there at number 2. They didn't call me.
His appointment may be invalid, but
So
he has no vested right.
So here he's R5, my lords. He's R5 here. I said so in my LPA. When the writ was pending before the Honorable Single Judge,
Whom did they appoint?
they appointed one Jot Karan, who was not even in the select list. Page 70 is the select list.
But look at it this way.
Yes.
Your plea was appoint you. You're not really concerned about his appointment.
In the writ petition, it was appoint me. When the judgment is reserved in the writ petition, on that day, they appoint this person. I filed an LPA. I said, how can you appoint him? You have to appoint me. The OM is there in my favor. The 3 judges is in my favor.
Did you ever challenge his appointment?
In the LPA. Because in the writ petition, he was not appointed. He was appointed on the day when the judgment in the writ petition was reserved. So I could not have made him a party in the writ petition. I made him immediately in the LPA. I made him immediately in the LPA. I made an application, and he's R5 here before your lordships. A person who is not selected is working, my lord, as a presiding officer of the Consumer Forum, and I was there in the merit list. As in the wait panel. OM says, my lord,
The petitioner, the grievance of the petitioner is that the candidate who was first in the select list, right?
very well.
The candidate who was first in the select list for appointment to the post of president of the Consumer Disputes Redressal Commission, Sangrur, resigned. Full stop. Thereafter, full stop. The petitioner was second in the select list. Full stop. According to the learned counsel, after the judgment was reserved by the single judge,
Yes.
and before it was delivered,
Yes.
the 5th respondent was appointed
Yes.
as the president
Yes.
of the District Consumer Disputes Redressal Forum, though he was lower.
He was not in
Though he was not in the merit list at all. The petitioner has been non-suited on the ground that once the first candidate Was it a fresh appointment then? They just picked him up without doing.
Picked him up without it.
All right. We have recorded your submission. The grievance of the petitioner, therefore, is that even if he was not eligible to be appointed as district, the grievance of the petitioner is that the selection of the fifth respondent is completely contrary to law, since his name did not figure in the merit list at all. Full stop. Issue notice, returnable on after 2 weeks. Thusly permitted additional liberty to serve the standing counsel for the state of Punjab in emergency. You have come here after 280 days delay.
Father passed away during this period. Father was very serious.
20 days is too.
20 days.
And on interest, claim is on interest in addition to the return of costs.
I invite your Lordship's kind attention at page 19 only. Page 19, just it has been recognized. It has
What's
been
the point?
approved. Yes.
What's the point that you want to make?
Well, it has been approved. It has been said that yes, this due is there.
You have to open that. To open the door, you have to first get the delay condoned.
My father passed away.
Petitioner, for which there is no satisfactory explanation. We'll stop. The petition is dismissed on the ground of limitation.
I circulated a note yesterday evening.
Yes.
My point is that it's a statutory violation. I'll be under remedy.
Tell us one thing. After the conciliation proceedings failed before the Facilitation Council, you have said that they never called upon you to file a statement of claim.
No statement of, I was a defendant, so no statement of claim is filed, no evidence, nothing. Just that the initial claim form which is filed before the MSME, which is a unrecent, just one page of form. On that basis, only the ultimate order is passed.
Did you get to file your statement of defense?
We did get to file. We got to file. But the conciliation, how it failed was that the first day I show up without the wakalatnama, that day itself the other side prefers an application, already pre-drafted application. And on that basis of the application, same day, immediately the order is passed, there's no conciliation possible, let's move. But Section 65 of the Arbitration Conciliation Act says mandatorily both sides have to be called upon to file the written responses, and the conciliation has to happen in good faith. Even UK law and all, they have gone on to that level where they say that good faith.
That conciliation failed. Thereafter, what happened before the?
No conciliation happened. Then I was called upon to file my defense. I filed. Then arguments reserved. Some fellow, Mr. RK, heard the arguments. The ultimate award is passed by some other 3 people who have not even heard the matter. So RK is the signatures on
You've come here against which order?
I've come again the order passed by the division bench of the High Court saying my 34 is not maintainable. I should have gone on 34. Writ petition is not maintainable.
But you have a remedy under 34, right?
I won't have a remedy under 34 because Section 65 violations of the Arbitration Conciliation Act are not palatable under 34 grounds.
No, but what you are aggrieved by finally is the award.
I've tried to draw a distinction from the Indian Blackwash judgment, which is falling for my lord. I'm conscious of that. There's a Jharkhand Urja judgment in my favor, which says if the mandatory statutory violations have taken place, then writ petition is maintainable vis-a-vis the MSME Act. Squarely covers my case. Number 2, my lords, the Indian Blackwash judgment and other judgment which my lords have held, those are cases where people are trying to make their cases on merits of the case. I am not on merits at all. I am on the violations of the MSME Act. And I am trying to portray my case there, my lords. So my humble submission is basic structure 226, etc., will be attracted when statutory violations have taken place. If it was a case on... In fact,
problem is that you are yourself saying that you're not challenging it on merits, but only on statutory violations.
The merits grounds are also there. I'm saying for the statutory.
The merits which you raised was that they were not registered as a micro MSME on the date of the agreement. So there's a finding of fact concurrently that they were registered.
What has happened is those merits arguments are also there. But to distinguish my case from the previous judgments, That's why I'm trying to portray my cases there.
It's sold, supplied, and delivered. You have not paid them.
No, my lords. That's not the case at all. My lords. The case, my statement of defense is not on record. My apologies on that. But what if the transaction is slightly different?
Balance of the principal amount of 24.82 lakhs was not paid.
Because I'm ready to deposit the principal amount. That's no difficulty at all. But the point is, my lords, my defense could not be brought on record because there's no procedure that has happened. There's no basic arbitration and conciliation norms that have been followed. In fact, my lords, there's one Delhi High Court judgment which says if it shocks the conscience of the judge, then the writ petition is maintainable, even against MSME matters.
In a petition under Section 34, all these grounds, suppose in an arbitration, forget the MSME Act, arbitrator doesn't hear the defendant and passes an award. Is that not amenable to a 34 application?
I brought on, my lords, the mandatory provisions of Arbitration Act not followed, ground under 34, absolutely correct, my lords. But my lords, this is under the conciliation process of Section 65 violations. So they may not be fall under the 34, my lords.
On conciliation.
And besides, my lord, one person hearing the matter, other person passing the award, who I don't even know.
But why did you not choose to challenge the award under Section 34?
My lord,
all these grounds are available. That's your ground is a violation of public policy.
My lords, I'm only saying, my lords, that under the Jharkhand Urja matter, I'm squarely covered, my lords.
Thereafter, it becomes an executable decree, right?
My lords, may I say this, my lords?
So the rate is that you don't have to deposit.
My lords, may I say this, my lords? The Jharkhand Urja judgment which covers me is of 2021. My lord's judgment is of 2020.
Leave it open to you pursue your remedies under Section 34.
I'm so grateful, my lords.
The petitioner had an efficacious remedy of challenging the award of the Facilitation Council under the MSME Act by taking recourse to the provisions of Section 34(2) of the Arbitration and Conciliation Act 1996. This was the matter, the High Court was justified in declining to entertain the writ petition under Article 226 of the Constitution. Hence, we are of the considered view that the grievances which are sought to be raised in these proceedings can be addressed in a petition under Section 34. Full stop. Any observations by the High Court on the merits in the impugned order shall not stand in the way of the petitioner taking recourse to the remedies to challenge the arbitral award.
I'll be hit by delay, my lords, because now.
But you can say you were bona fide pursuing your remedies before the High Court. What else can we say?
My lords,
I can't condone the delay which is beyond now the 90 days.
My lords, that's there, my lords, but that will be read to me, my lords. It's a good case on merits, my lords. My lords have seen what has happened in this case, my lords. In fact, my lords,
we have vested right in yours to their benefit. How can we obviate a limit set by Parliament?
Because I understand that.
Then really speaking, if it's barred by limitation, you should just dismiss it. Otherwise, your client will spend another round of...
But my lords give me liberty, my lords may not rectify to my interest if the debt delay aspect is not covered.
All right. But we'll not condone the delay here. You have to move.
My lords may only observe that I may permit it to a day's response. That will be, my lords.
You can always say that condone it. But we can't, because there's a maximum period which can be, which is condoned. We can't go beyond that. Like the IBC, the Arbitration Act. Yes, condone the delay of 36 days in filing the SLP. There's no difficulty.
No,
then you can say I was pursuing my remedies bona fide before the Supreme Court.
I'm in my lord's hands for us.
They're condoned.
Item 11.
Sets aside, my lord, the well-reasoned decree and the judgment of the trial court. Para 15, my lord, it proceeds to record a wrong date, contrary to what has been pleaded by the plaintiff himself. And then, my lord, says that we were at fault in not pinpointing it promptly. My lord, three things were missing from the impugned judgment. If your lordships may please see, my lord, please.
You paid them 90% of the payment.
That's right, right.
So the dispute was only in regard to the balance 10%.
Lordship, please.
So the High Court says first, the very fact that you paid 90% shows that the work was being executed. Now, question is still, you may still have a point that, there were delays or deficiencies on the part of the respondent. Where did you raise the issue of delays or deficiencies?
No. We have said so in the written statement, coupled with the fact, my lord, there is a finding of fact that the work completed was only to the extent of 90%. And therefore, my lord, the learned trial court held this. My lord, please have a look at page 175.
So what evidence did you produce to establish that there were delays late?
Yes. 30th of next year, P11, your lordships may see. Or my lord, lordships may please have an next year P12.
Now, this letter, which we have pointed out, Lord, on 30th November 2012, the judgment in question says that you
Tell us what is the evidence which you laid.
Lord, this was one of the letters, Lord, 30th November, and the rejection letters at document P11. Kindly just see, Lord, annexure P11 from pages 102.
You had to prove your defense that there were delays and that there were delays or deficiencies by adducing the evidence of a person cognizant of the contract which was being performed, and then establish, by producing documentary material that, there was a shortage of work or there was measurement carried out which resulted in,
If I may say so with respect, my Lord, the annexure P11 pages 102 to 115 were the rejection notes. Then, my Lord, the chairman of the company appeared as DW1, and then, my Lord, 30th November 2012 letter, which was within the warranty period but not considered by the judgment in question, that has been set aside, my Lord, on the premise that the work was completed in July 2011. But the plaintiff himself says that it was in 2012. Para 19, if I may just draw your Lordship's kind attention, please have a look, my Lord, at para 19, page 187. That is, my Lord, the fundamental error, my Lord, in the judgment. Besides the point, my Lord, that para 19,
ultimately, you are here under 136.
I know, my Lord.
That's not a problem.
My Lord, only two respectful submissions. First and the foremost, my Lord, the evidence, etc., my Lord, even the bills which were presented. The learned trial court has held that these were not actually the bills which were submitted or ought to have been submitted. They have not been proved. Then, my Lord, there is a heavy discrepancy on my pointing out the deficiencies, because the High Court says, my Lord,
It's purely a matter of appreciation of evidence in our case. So, thank you.
Right.
This has to be tagged. This has to be tagged. Ganpati deal.
This has to be done.
Benami.
Commerce, but it's kindly see the tribunal's order for a minute. It's PDF.
You are appearing for?
Well, I'm on KV. I don't know what the bill.
We've got other matters which are pending, so we'll.
But kindly see this issue only on Ganpati reform, not on merits. And with the liberty given that if review is allowed by the Supreme Court, please come back.
Therefore, we'll tag it.
The request is because ultimately even my lords tag it.
We've got other matters pending.
I'm not saying no. It's not that they are remedy left. Tribunal says if the review is allowed, please come back to us. That's liberty.
We'll keep it here.
On merits, ultimately.
We don't want to follow a different course of action because this will affect other matters which are pending. So we should notice and tag.
Let's dismiss the numerous matters.
We'll keep it. We'll keep it here. Yes.
Well, ultimately, because my lord will be sending back to the tribunal.
All right.
Right.
My lord, I'm humbly praying for a Passover, my lord.
Tell us what the matter is about. You argue.
My lord, the learned Solicitor General is leading us, my lord.
But for us, you are the Solicitor General at this moment. Tell us what the matter is about.
My lord.
The matter is about.
Argue for 5 minutes, then we'll look into.
Mr. Solicitor, just one second. Let your junior argue the matter. Please sit by his side. Yes. Tell us what the matter is about.
My lord, the matter is about non-filing of affidavit of admission denial along with the written statement, my lord.
So the High Court has relied on the Delhi High Court rules,
my lord,
according to which the list of documents has to be filed at a much anterior stage. It says without an affidavit of admission and denial, right? So the written statement, it says, will not be taken on the record without an affidavit of admission and denial.
My lord,
that's the Delhi High Court rule.
That's the Delhi High Court.
That's why you have been non-suited. Now, what is your answer to that?
My lord, CPC Order 11, Rule 4, my lord.
Yes.
It is very clear, my lord. The affidavit of admission denial has to be filed after interrogation and investigation of the documents have been done, my lord.
And what does the Commercial Courts Act say?
Commercial Court Act, my lords. This is the Order 11, Rule 4 as amended by the Commercial Court Act, my lords.
Right, but which is the provision of the Commercial Courts Act?
My lord, the Commercial Court Act amends CPC.
Which is the provision of the Commercial Courts Act which you are relying upon?
Page 15, my lords, of the impugned order.
Solicitor said 15, so you said 15. Hello, decision order. Oh, right. We have heard Mr. What's your name?
Avinash Agarwal.
We have heard Mr. Tushar Mehta, learned Solicitor with Mr. Avinash Agarwal, issue notice, tenable on till so and so for the proceedings. Should we stay the proceedings for the proceedings in the
The real question would be, the High Court says
the rules will prevail over the Act, over the CPC.
There are 22.
Returnable on so and so. Pending till the next date of listing, there shall be a stay of further proceedings in the suit. I don't know. Here, what happened was that they, right. What 23 days to issue notice on
advocate underwent some ISIS.
Item 14. Madam, I beg to appear on behalf of the petitioner. My lord, firstly, my lord,
the issue is as to whether after the appointment of the arbitrator by the Calcutta High Court,
yes,
the Tripura Commercial Court would have refused to refer the matter to arbitration. And I think that is
my lord,
we have not appointed an arbitrator.
without examining and considering the records that were lying before the arbitrator, which is completely a separate set of pleadings, my lord, before the arbitrator. My claim before the commercial court is completely independent of the dealership.
All this can be argued before the arbitrator. Why should we entertain it at this stage?
The arbitrator, the Arbitration 11 application on the basis of which the arbitrator has been appointed by the Calcutta High Court, my lord, is based on arbitration agreement.
Overall, the long and short of the story is that it can be sent to the Arbitral Tribunal.
My set of pleadings in the commercial suit is completely independent of the dealership agreement. I am not at all governed by the dealership agreement. There is a basic misunderstanding on the part of the court, my lord. Secondly, my lord, without considering and examining the records lying before the arbitrator at Calcutta, my lord, the court could not have at paragraph 18, my lord. If your lordship kindly turns to page 15, paragraph 16.
What has the High Court done? The High Court has said that let the commercial remand order, saying that the commercial court should consider this.
Yes. Well, there could be parallel proceeding. Well, without looking into what was there before the arbitrator, the set of claims that were completely different, and my claim before the is a money suit, my lord. It's a simple money suit. It's a commercial claim. It is not a case of claim and a counter claim. My set of facts are completely independent of the dealership agreement. Paragraph 10 of the plate, my lord, that is a different set of facts. Secondly, my lord, the High Court had interfered with
Who are you actually? Who are you in the sense? Who is your client?
My client is the instant petitioner, my lord, who has filed the commercial court in the Tripura High Court, in the commercial division court.
You are the dealer. Yes. You are the dealer.
No. Yes, I am a dealer. I am a dealer, but not eminently.
Maybe you are saying that your claim is independent of the dealership agreement.
Yes.
Your status arises as a dealer under the dealership agreement.
No, that
dealership. The High Court says, please consider our order to direct the commercial court to consider their order appointing an arbitrator.
Yes. Well, the arbitration agreement, which is between me and the dealer, maybe, my lord, it's an alleged document, is not at all a document which is with my custody. I have specifically stated in my plaint that I have never seen, this document has never seen the light of the day. In that event of the matter, my set of pleadings in the commercial court could have been in the light of the dealership agreement.
All this has to be looked at by the arbitrator.
Arbitrator deciding on the dealership agreement. That is for the respondent. That is the claim of the respondent against me. My claim against the respondent is completely different, and my suit is a prior.
You heard your point. No, it has to be before the arbitral tribunal. But anyway, we are not directing it has to be sent to the arbitral tribunal. The High Court has merely remanded the matter, directing the Tripura Commercial Court to consider its order, Calcutta High Court order appointing an arbitrator. That's all.
But this is where I join my issue, my lord. Just one day.
Now I think we've made access.
To stay, my lord, the Calcutta.
Lordship, in item 15, it is in my humble submission that the Honorable High Court has committed grave error in saying that the minor dispute was transferred to respondent number 1 because it was transferred without following the provisions of law, and according to me,
But
it is
before
void.
that, you have to answer why we should condone the delay of 170 days in filing the SLP.
My Lordship, because the petitioner was not knowing that there is a limitation in filing the SLP in the Supreme Court, and the advocate who was dealing with the matter in High Court.
On the ground of delay, yes. Thank you. Item 16.
My Lordship, may kindly consider as soon as we got the matter, we got it filed. My Lordship, may kindly consider, because the petitioners are also very not very poor. My Lordship.
They have been in possession of the mine for the last 50 years.
But my Lordship, that transfer was illegal. My Lordship, that was
not case for injunction. The High Court says that somebody who's in possession of a mine for 50 years, they can't be now injuncted like this. So if we are discussing, we can say this. We can even say this. Though there's a delay of 170 days in filing the special petition, we have also examined the correctness of the impugned order on merits and find no reason to interfere with the order. Especially petitioners accordingly dismissed both on the ground of delay and on merits. That's better, so that can be. Item 16.
Blacklisted issuing any show cause notice and contrary to the terms of the tender itself, with my Royal Lordship's attention to page 98.
Cancellation maybe. Senior Counsel appearing on behalf of the petitioner submits that the petitioner was blacklisted.
Not
returnable on.
Lord, we are only requesting for a stay, Lord, because I won't be in a position to participate in any of the options, Lord. Lordship.
Oh, I see.
Lordship.
It's a due process.
Of like.
Issues have been disposed of by the High Court. All the matters are not listed today. They pray for a one day.
But there's a 174 delay, 174 day delay here.
No. As far as the first matter is concerned, there is 74.
174 day delay. 17. How many matters are there on 17?
In total, there are 7 matters. All the matters are not listed today. It will check on after a real matter.
You can get your other matters. We'll discuss this on the ground of delay. How can the state keep on saying that, look, there are other matters where there is no delay, therefore condone?
I'm not saying. Please take up all the matters together because they are not delay. What is concerned?
We will keep those other matters. We'll discuss this on limitation. Limitation applies equally to everybody, and I think state governments in India now must be absolutely alert. And merely because it is a state, the government officers cannot just sit and allow.
74, my lord.
And it's serial number 37, there is 74 days delay. We'll look at that matter independently. When it reaches, we'll take it up. This one we will dismiss on the ground of limitation.
My lord, I'm just saying that we'll take because on the technical ground, kindly see, my lord. Technical ground, my lord, they have to more than 3 or 4 crore rupees, my lord, kindly see. They have to pay more than 3 or 4 crore rupees, my lord, kindly see.
7 reaches. We'll see what the merits.
All the matters are not listed today, madam. If you taken after a week, madam, all the matters, madam.
How many are there?
In total, there are 8 matters, madam. Only 3 or.
Give the number to the numbers.
Yes, I will put the numbers.
List together with so and so.
On Friday, madam. Next Friday. In the meantime, if there is defect, I will put the defect all day.
Item 18.
But it's on Friday, madam.
Next Friday.
This is a really piquant and unjust situation where I can't appoint an arbitrator. The matter is under litigation. Their appeal has been remanded by this Honorable Court to the High Court because it was earlier dismissed as non-maintainable. So the arbitration award has been set aside as being perverse at my instance.
The arbitration award was set aside by the single judge.
Section 34 judge.
Justice Dhanuka's judgment.
That's right.
We had dealt with this.
Justice Baldota's judgment.
Justice Baldota's judgment. There was a similar case which just came a few days back where there was the division bench set aside Justice Baldota's award on the
ground of perversity.
On the ground. What happened in the single judge?
No, thereafter, after the award was set aside on the ground of perversity, they filed a Section 37 application, which was dismissed as non-maintainable. Then they came to this Honorable Court. This Honorable Court found the appeal was maintainable and therefore remanded it. When therefore this matter is still pending litigation and the situation is that a perverse award against me has been set aside, behind my back, 2018, they enter into a development agreement with respondent number 3. This is not disclosed. It is disclosed for the first time in 2023, where when I discover by chance that a huge construction is being put up, I move an application.
Mr. Ramchandran, what is the investment by your client?
The investment by my clients is 22 lakhs in a matter of 1.5 crore at that time. The amount should not matter at all, my lords. That was the initial payment.
You know, if a construction has taken place, and now you have invested about 22 lakhs.
He has paid 8 lakhs, my lords. The respondent number 3 has paid 8 lakhs. It can't go by the figures.
What seems to have also been impressed by the fact that now impeding the development, the tenants on the property who are waiting for being rehabilitated.
With respect, my lords, with respect, those tenants who are part of the original bungalow, it's not some resettlement scheme. It is a bungalow which is being demolished and a 15-story structure is being put up.
The award against you in the arbitration, right? The award in the arbitration. What is the actual award in the arbitration which was set aside?
The award was that I am not entitled to specific performance and I am not entitled to damages, both of which have been set aside because the award has been held to be perverse. So the matter is at large and I file a fresh Section 11 application for the reason now that this third party has come. This third party seeks to get implemented in that appeal. And I can't appoint a Section 11. Award was that my claim was dismissed. My claim was against his reneging on the 2005
So your claim
MOU.
for essentially for specific performance or implementation of the MOU, that was rejected by the arbitrator. The single judge set aside the award and just set aside the award simpliciter.
Simpliciter. On the ground of perversity, but set it aside.
Right.
Therefore, fresh arbitration has to start. In any case, a fresh arbitration has to start. Immediately after the appeal was dismissed by the Bombay High Court, I filed a Section 11 application for fresh appointment of an arbitrator.
The appeal is by the other side, of course.
The appeal by the other side. When that appeal was dismissed, I filed a Section 11 application. But then this honorable court remanded the matter back to the High Court. So logically,
even assuming that ultimately in the appeal the award is affirmed, you still have recourse to a fresh Section 11.
And that is not being allowed by the impugned judgment. That is what is not being
They
allowed.
have created third-party rights in the meantime.
Lordships, and they have created third-party rights. And well, a fault is being found with me.
We'll have to consider this because you have been non-suited even on your
Lordship, please.
Section 9 or something, we may or may not be with you.
Section 9 minutes, my request is this. If behind my back, this agreement is entered into and not disclosed to the court,
You're also a very big builder in Mumbai.
Please.
There's nothing behind your back. You see the whole construction coming up, and you said a big building is.
I happened to see it because I was passing that way. I'm not traveling on all the roads of Bombay every 10 minutes. I'm not traveling on all the roads of Bombay.
This is not by this.
On section 9, if your lordships are issuing notice.
11, perhaps you have a point that at least your remedy under 11 can be kept open. Depending upon the outcome of that appeal, perhaps we'll see.
On section 9, my only limited prayer is this: as your lordships issue notice, let them not create third-party rights in favor of buyers. Let them not.
We are issuing notice. We'll make a short notice. We don't want to issue an interim order without hearing them. Serve dusty and come. We'll just rise. Members of the bar will rise because our distinguished colleagues from Brazil has to go around the court and look at the facility. We just rise for 2 minutes. And
before the learned wizard minutes rises with your lordships, I thought an anecdote, seeing your lordships encouraging a junior a few matters back. 48 years ago, minutes, in court number 2, Senior Justice Chandrachud was the presiding judge, and a 2-month-old lawyer, namely yours truly, was appearing before him, shaking with nervousness. And Senior Justice Chandrachud looked at the appearance slip and said, "Yes, Mr. Ramachandran," which gave me such confidence that I was able to argue a useless matter for 5 or 10 minutes. So I was reminded of that day, minutes.
Thank you, Mr. Ramachandran.
But can I request minutes for dusty in addition, minutes, so that it comes in 2 weeks?
We just told the court master it will be served dusty and after 2 weeks.
And no third-party rights minutes in the meantime.
That's why we are giving you 2 weeks. Thank you.
Lordship, please.
Has been overruled subsequently. But at that stage, at your behest, he was sent to the arbitrator. You didn't object to his
By the
conviction
High
before
Court.
the arbitrator.
By the Honorable High
Right.
Court.
But then you never objected before the arbitrator. Now there's an award.
It's a matter of record that we objected only at the stage of 37, my lord. I cannot quarrel with that.
We'll dismiss it. What we'll do is we'll dismiss it on the ground of limitation, so that it doesn't become a precedent in any other case. And we'll keep the question of law open. There's a delay of 235 days in filing the special petition against the judgment of the Madhya Pradesh High Court dated 9 December 2022. Full stop. There is no satisfactory explanation for the delay. Full stop. Hence, the petition is dismissed on the ground of delay. However, we clarify that since the bar of limitation has intervened, it has not become necessary for this court to express any opinion on the question of law raised.
It will remain open, my lord.
Which is kept open. We shouldn't say it's open because actually the question of law is decided in your favor by our judgment of 2018. Because the judgment in VA Tech has been overruled by our court.
That is
so if we keep it open, we are tacitly then casting doubt on our judgment. The question of law is in your favor. Just that we are not interfering in this case at least.
At this stage, my lord, if I may only...
We will say it's kept the question of law is kept open. Fair enough. You wanted to give it.
I'm very grateful, my lord.
Please, my lords, this petition has become infructuous because subsequent developments have taken.
Counsel appearing on behalf of the petitioner states that the petition has been rendered infructuous by subsequent developments.
I'm sorry, I want the question of the law to remain open, my lords. Simply being, my lords, because this was the second petition, my lords, pursuant to a settlement agreement. And Lordship's court has
always open queas. Nothing is concluded by us. We are just saying that it's infructuous. Item 4.
My lords, it will ultimately, the matter will ultimately be the Lordship's court only. So I'm just.
So it's always open queas. We are saying it's disposed of as infructuous. It can never bind on a future bench.
Okay. I'm very grateful, my lords.
This matter, admittedly, the NCLT finds that my claim and my allotment to the flat is reflected in the information memorandum, which is the basis of any resolution plan. And it is showing in the record.
What about delay?
Yes, my lords. On delay, my lords, admittedly, I am not present when this pronouncement is made. My lords, the matter is reserved 3 months back. It comes in a pronouncement, my lords. My appearance is not there. I have vehemently said that I was not present. It is uploaded, my lords. And
what is the date on which it is uploaded?
My lords, it is uploaded on 22nd of August 23, from which, my lords, I am within limitation, excluding the certified.
You were not present. Were you a party?
Yes, it was my application, my lords. On my application while reserving.
But then, if it's your application.
Yes, my lords.
Then can you say that I was not present? I don't know because.
So, my lords, the arguments happened. The order stands reserved.
But it is.
Not
when is the order pronounced? Actually, it's not pronounced at all.
Not on the dates argued, my lords. Not on the dates heard. It comes up in the list 3 months after for pronouncement.
22nd August.
No, my lords. 11th of August. 22nd August is when it is uploaded, and which is when I gain knowledge of the order. And I, my lords, file immediately. I filed the appeal immediately.
So then, counsel appearing on behalf of the appellant submits that that in the application which was filed by the appellant, though the order was passed by the National Company Law Tribunal on 11 August 2023.
Yes.
The order was uploaded only on 22 August 2023. Hence, it has been urged that the appeal which was filed on October 2023.
Yes. 10th October 23.
10 October 2023 would be within the period of limitation of
61-2.
The limitation. We'll issue notice.
Great.
Returnable.
Malaj, may I only make one request? The resolution plan basis which my application was dismissed even to date has not been approved by the NCLT. Now, Malaj, may I only request for an interim stay?
We'll make it returnable in 2 weeks. Wait for stay everything. Serve dusty and come.
So good.
See, in this case, the NABARD, though initially it said that there may be certain irregularities in the functioning of the bank, subsequently it filed an affidavit before the High Court stating that the resolution of the board was proper and that there were no irregularities. Ultimately, this was a public interest litigation. You brought some grievance to the attention of the court. The court has felt that it is not necessary to interfere.
Page 368 may be seen, Lord, for a moment.
What is that?
Ordered by High Court, Lord, Honorable High Court.
The earlier High Court, the earlier order.
Yes, Lord. It says, Lord, pursuant to previous order, action taken, report on behalf of the NABARD has been placed on record. Prima facie, certain allegations were stated to be true.
But that is prima facie. Subsequently, NABARD files an affidavit and says that we have now looked at it and there's nothing.
Later, Lord.
Anyway, as a PIL petitioner, your duty was to point it out to the High Court. High Court went into it. NABARD. Deposited, the amount has been deposited.
Has been transferred to
Delay in deposit of costs. Mr. Surat Singh states that the cost of rupees 5 lakhs has been deposited.
last year, Lordship.
No, with the delay of 48 days. The delay is scheduled. Yes.
Grateful, Lordship. Lordship, I may request a password.
My Lord, in item 25, I may request a password. I mean, led by Mr. Akhil Sibbal.
Okay, we'll keep it some other time because we have some other matters. We'll keep it on Monday.
Very good.
26.
Hey, please put a clear abuse of process of law, minutes.
Fine. The quashing application has been dismissed on the ground that you are running an unregistered fine.
General allegations, but that is not the case. That is not the case at all. Now 4 lines for the improved order, which is only general allegations against me. What was argued? It is not the charge sheet form in part of the charge sheet. Charge sheet will not kindly consider. But power of attorney was executed in favor of my father, not in my favor. That was in 1998. My father sold the property on 12/7/2001. The purchasers are in possession of the property from 2001 onwards. In 2017 and 18, 3 civil suits were filed, one by his daughter, one by his sister and other. Questioning the very same sale made by the first accused. Those suits are pending in which he remained ex parte in 2017 and 18. Then in 2019, he makes a complaint.
Quashing stage based we consider that said.
Clear abuse.
Quashing, but you can seek discharge or other remedies.
So far he is concerned, I understand that. But my humble submission would be, because the entire transaction involves only my father, 1998 and 2001. At that time, I was hardly 18 and a half years old. I got nothing to do with that transaction. I did nothing.
Whether you subsequently had a role or not really where we can consider the sale of quashing. Discharge, yes, at that stage a little bit more
this will give room for another round of litigation. When you not will appreciate it, but it is so clear that it is when it is.
There is nothing to know. There are limitations on 482 quashing petition, and there is not a case for quashing.
May I take 1 more minute's time, subject to my not permitting me?
Sorry?
1 more minute's time, minutes?
Yes.
Your Atma kindly say after how many years your parents were registered?
Yeah.
In 98, power of attorney in favor of my father, not in my favor. My father sold it in 2001 to third parties. Third parties have been in possession of all these years. In 2019, complaint. At the time of transaction 1998, I was hardly 18 and a half years old. There is no allegation against me. Now, after 18 years of the original transaction, when the purchasers have been all along in possession, for the first time, this complaint is made. Civil suits, 3 civil suits are pending. 18 years.
kindly make one observation that observation made by the High Court will not stand in my way when I move for discharge.
That we can say. We are not inclined to entertain the special petition against there's no error in the order of the High Court declining to quash the criminal proceedings exercise of jurisdiction under Section 482 of the Judicial 1973. However, the observations in the imprisonment order of the High Court will not address the petitioner in either seeking in applying for discharge or at any latest of the proceedings, as the case may be.
Liberty to file for discharge petition.
We have said that. Not liberty, but we said it will not come in the way of these observations will not prejudice you in your application for discharge. Yes. Now you are expanding it not just to Delhi but to the rest of the country.
Reason, my lord, I have my own reason, my lord.
Who's appearing for the Union of India here? Notice was issued by Justice Arun Mishra and Justice Emma Shah in 2019.
And
can you file a proper affidavit explaining, he's dealt with issues of suicide by children? It's basically more
filed an affidavit. We'll file a detailed affidavit also with respect.
The Lieutenant Counsel appearing on behalf of the Union of India states that response to the petition, a comprehensive affidavit of the steps which are being taken to allay the grievance in the petition shall be filed. The affidavit be filed within 4 weeks instead.
May I have only 2 minutes, my lord, if my lord permit, my lord.
No, we just allow them to file an affidavit and then come.
They have filed, my lord, the latest affidavit they have filed, my lord.
When have they filed it?
My lord, it's, my lord, on the last date, my lord, which is, my lord, on 19th of, my lord, May 2023, my lord, they filed.
So let him, he wants to, it's a social issue, so let him file an affidavit.
A specific date may be given.
Yes.
So I beg to appear, Manats. We have compiled a chart of 28 states and UTs who have filed an affidavit here. It doesn't have 8 states and UTs, actually 3 states and 5 UTs, Manats. May I hand over?
On the implementation of the NALSA judgment.
Yes, so we've culled out from their affidavits, Manats.
Some of the states have not filed affidavit, your lordship.
28 states and
3
UTs.
states and 5 UTs have not filed an affidavit.
It have not filed, Manats.
8 total.
States and
5 UTs. Which are the states which have not filed? It's all right. You can ask one of your juniors.
Write down and give it, Manats.
We give them enough time to file and direct the chief secretaries to ensure that affidavits are filed by them.
That's so that the chart can be then completed, Manats.
You can update the chart. Mr. Aishwarya Bhatwi has placed a tabulated statement indicating state-wise compliance with regard to the with regard to Direction 3 contained in the judgment in NALSA versus Union of India, 2014, 5 SEC 438. Stop. 3 states and 5 union territories are yet to file their responses, namely,
I'll give the...
Just ask your junior to put it down. We direct that the above states and UTs shall file their responses no later than by 31 August 2024. Stop. A copy of this order shall be served on the Standing Council for the above states /UTs. Copies to the chief secretaries. List on the chief secretary.
Your lordship, may I pray one thing, your lordship? There is another read petition, your lordship. Your lordship,
Yes, sir.
There is one more read petition where your lordship has issued notice, your lordship. Read petition number 535 of 2023. That is covering a broader issue of including this filter. That may be tagged on this matter, your lordship.
I am not aware, Manats. I'll take details from you.
Next time, or can you give details?
Read petition number 535 of 2023.
Just examine, ask one of your juniors to examine 535 of 2020 and let the court master know by the evening.
Please, my lord.
I have brought a copy of it. Let's see.
My lord, I will see.
All right, just see that.
Thanks,
Yes.
I'm
535 of 2020.
Okay, Your Lordship. Mr. Appointment, you are appearing to be appointed an arbitrator.
Not to request, no. It should be the Bangalore Center, Bangalore.
Bangalore Arbitration Center, under the auspices of the Bangalore Arbitration. How much is the claim?
Well, there's some joint development agreement because the petitioners are in America, they have to come here, my lord. Happy to concede that, let it go to the Arbitration Center, Bangalore. Let them appoint an arbitrator.
An arbitrator from Bangalore here, you tell us whom we can appoint.
But we have suggested, my lord, sir.
Why don't you both give us a name? It's just 1.38 crores, no point in appointing a retired...
The Arbitration Center has a setup, my lord, where they, by claims, they currently resolve.
In view of the arbitration agreement between the parties, we refer we direct that the arbitration shall take place. There's an arbitration agreement. The arbitration agreement between the parties is not in dispute. Disputes having arisen, the position of the arbitral tribunal would have to be the arbitral tribunal would have to be constituted. The parties are referred to the Bangalore International Bangalore Arbitration Center, so that necessary directions in that regard can be issued.
The request, my lord. One which may have settled on a change, it has become an LLP, maybe report. And friend wouldn't know, but
the respondent, having undergone a change, invited in the legal counsel liberty to amend the petition when amendment be carried out during the course of the week. This is give it to him so that he can, and then the order and petition disposed of.
we'll do that.
Only appoint an arbitrator.
How much is the claim in Indian rupees?
About 2.7 crores, my lord.
2.3 crores. Right. They're appointing you as an arbitrator in one matter. They're pleased to look at it.
One more request. This place is the place of arbit is Indore in Madhya Pradesh.
That's all right. You can do it online now. All arbitrators do their arbitrations online.
If your lordship permits, we have suggestions of union. If your lordship permits.
Here we are at the point now. Yes. Admittedly, there's an arbitration agreement between the parties. We appoint Ms. Mayuri Raghuvanshi, counsel, as sole arbitrator under the Arbitration and Conciliation Act 1996. The sole arbitrator shall be at liberty to fix her fees in consultation with the parties. Parties have agreed that to the extent feasible, the arbitration proceedings would be conducted online. To the directions of the arbitrator. अच्छा है ना, छोटे छोटे claims हैं आगे इस पर
I beg to appear for the respondent. This doesn't lie, my lords, because clause 16.5 is a jurisdictional clause for courts, and clause 18 is actually a clause which says it's governed under Colombian law for a Colombian authority to appoint an arbitrator, and it's a very interesting clause. It's actually a med-arb clause.
Let's see, I got it here. Let's see. got it here. Let's see his clause.
The head, sorry, page 42. In fact, it falls under the head miscellaneous. Miscellaneous is at clause 16, which is at 41, and 16.5 is at 42. It says the agreement shall be governed by and construed in accordance with the laws of India, and all matters pertaining to this agreement or the matters arising as a consequence of this agreement will be subject to the jurisdiction of courts in Gujarat, India. That's one clause. Now, please have a look, Milords.
It says arbitration will take place in Bogota.
Correct. Now, this is very interesting. This is actually a very interesting clause. If your Lordship sees the first paragraph of clause 18, it talks about a conciliation. So it's a non-mandatory provision. Says parties are, if they want to go for conciliation, they can go for conciliation in accordance with the rules of the arbitration and conciliation of the chambers of commerce.
If conciliation is not successful, it will be committed to arbitration by either party for final settlement in accordance with the Arbitration and Conciliation Center of the Chamber of Bogota.
I'm deeply grateful, and if your Lordship was to please see with the wordings, it's very interesting. It is what is unresolved in the conciliation that goes for arbitration. Now, they haven't even gone for conciliation. So if you haven't even gone for conciliation, and it's a matter, Milords, in fact, in my respectful submission, your Lordships has some judgments under Indian law on this issue. One is Jagdish Chandra and one is your Lordship, my Lord's own judgment, which I would say your Lordship should not even apply here because this is a Colombian law governed clause. Please see the bottom of it, because it's very clear that it says it's Colombian law. So I would not, in fact, hesitate in even interpreting this clause under Indian law. It's not for us to interpret. So my respectful submission should be that this section 11 should be dismissed.
They seem to have lost interest. Will you dismiss it in default?
I'm deeply grateful.
Yes, ma'am. So after your counter, nobody is appearing. If they come, we'll see. We'll restore it and hear you then.
I'm deeply.
Yes.
I'm deeply obliged. I think two arises out of two connected agreements where I'm seeking the appointment of a tribunal. So they have filed their counters probably before respondent 3 because also, my Lord, I am asserting some parties who are not signatories to the arbitration agreement, but, my Lord, are connected and part of the group companies doctrine the Lordship judgment. But with regard to their...
That can move the arbitrator.
Yes, then... Tell your Lordship, there's a problem. So there are two... Sorry.
What about those arbitrational parties who are signatories to the arbitration agreement?
Well, there are two cases which are there before your Lordship. In first case, which is a joint venture agreement, your Lordship will kindly give and note down these dates, they are important. The first joint venture agreement is 2nd of June 2016. This is in arbitration petition number 47, which is item 32.1. Now please note in this, there are two parties, Zonta Holdings and Bauer. Bauer is the name of my client, the company.
They are Zonta.
They are Zonta. Zonta Holding and then Zonta Infra is their subsidiary. So the first agreement is a joint venture agreement, which is 2016, Zonta Holdings and Bauer. There is an arbitration clause here, which is clause number 14 at page 77.
Yes.
In this, my only defense is that there is a pre-reference mechanism which they have not followed. That's clause number 14.1. But we had to try to settle it amicably. They've done nothing.
So here, really speaking, one can appoint an arbitrator. Subject
I am leaving it at that. I am not taking your Lordships to anything else. Now, please mark one thing, and that's my defense in the other case.
So 32.1, we can appoint an arbitrator.
32.1, I leave it to your Lordship.
What's the claim there? What's the claim there?
There is a monetary claim of about 180 crores. But Milord, I'll just say one thing, my friend can continue, Milord. The first agreement that my friend is referring to contemplates an arbitral tribunal of 3 members. The second agreement, Milord, which is interconnected, contemplates a sole arbitrator. We were requesting, Milord, if it can be the same tribunal, a consolidated hearing or even separate hearing.
Now, what about the first matter that is...
Yes, now let me come in there.
Then we can ask them to respond to that.
So grateful. Now the second matter, which is actually the lead matter, is arbitration petition number 49, item 32. 49 of 2023.
Yes.
In this, the basis of section 11 is an ESDF agreement, which is equity subscription and debt financing agreement, the date of which is 21st February 17.
Yes.
I'm sorry, I'll just repeat. ESDF
21st
February 17.
Yes.
Now this ESDF agreement is entered into between three parties. That's my other client named Mr. Patrick in his individual capacity. Please note that. These clients are Zonta Infra and Zonta Holding. Now, as the names of the contract suggest, the first contract is whereby both of us agreed that we'll have a joint venture company and we will engage into XYZ. There is no liability. In fact, I have a pleaded case before your lordships that he's trying to mislead this court when he says both the contracts are connected. They are not connected. First is a joint venture agreement. The second agreement is where my director in his individual capacity has purchased equity from him and has financed debt, which is what the agreement also says. Now there is an arbitration clause there. I agree to that. No problem. That is clause number 15.6 at page 123 in case number 47 itself. I'm taking page numbers of only the first case.
Yes.
Now,
in 47,
yes,
the arbitration agreement you said is clause 14.
Yes. In, however, ESDF, the arbitration clause is 15.6
right.
at page 123 of petition number 47.
Okay.
Right? Because I'm giving page numbers of only one. I don't want to confuse you. Now, there is a parallel third agreement, which is an SPLC, sort of a line of credit that I give to him. Again, my company gives, in which there is no arbitration clause. He's not even invoked that, so I'm not going to. Post the second agreement disputes, ESDF, there was a settlement agreement which is entered into. Now, that is very important. The date of that is 6th October 22. That your lordships will find at page number 132 of petition number 47. What he does in the, what he does in the settlement agreement is he says that yes, I will pay you this money in XYZ period. There is no arbitration clause there. He wants to go back to the parent agreement, whereas my settlement agreement says that the previous contract is over. Please have a look at that. Now that specific clause.
Settlement agreement
yes,
says that which contract is over? The
ESDF.
ESDF.
Yes, clause number 13, page 135. Please have a look at that. That's the most important clause of petition number 47. Clause 13, page 135.
Now, his grievance is that you have not implemented the settlement agreement.
And that the settlement agreement is entered into because of coercion on him. He has to get it declared as illegal. How can he invoke section 11 for that? Your lordship's judgments from way back.
Except for the fact that the settlement agreement was entered into in lieu of his claim, in satisfaction of his claims under the ESDF.
Yes.
If he says that the settlement agreement has not been implemented, right, or that the whatever defense, can he not then fall back on the ESDF agreement to get that issue adjudicated?
In fact, the point of law that arises in this case. Now, let me show to your lordship's Gimpex.
Because but for the ESDF, there would be no settlement.
Yes.
Right? And we must construe this in a broader sense to facilitate arbitration. Now, but for ESDF, there would be no settlement. It's a settlement of disputes within the ESDF agreement. If that settlement has not, according to them, come through, surely we can invoke arbitration.
Let me only show law on this specific point because I've done some work. There is a judgment by your lordship.
Unless the settlement agreement says that his claims are extinguished. His claims are not extinguished.
Well, in fact, the settlement agreement recital says what? It says parties have agreed to rearrange and revise the inter se relationship, which means that this is what survives now. It is not the parent agreement which survives. The SPLC as well as the ESDF.
It's an ovation service.
Yes. So once novation occurred and challenged,
that's again for the arbitrator. And they're challenging it on the ground that I'm really never a party to that. So whether it was by coercion, not by coercion, it's for the arbitrator.
My submission.
So what we'll do is this. We'll appoint an arbitrator now. Now tell us what is the claim in both the matters.
I am the one who's pocketed out of money. They've not paid me back. There are allegations of siphoning against the Indian party. And now they say that they have a 200 crore claim. I'm not getting into the merits because I don't want to.
So whom should we appoint?
Apologies.
Yes.
Number 3 is the ESDF, the JV agreement, or to the BLC. The party in the settlement. My role in the entire.
All right, 1 second. Now, who are in the second matter, namely 49, ESDF agreement is between, you said it is between the petitioner Zonta Infra and Zonta Holding.
Yes.
Then you said Patrick in his individual capacity.
Patrick in his individual capacity.
That's all.
That's all.
No, my lord.
Nobody else.
These are the three parties to the ESDF, what your lordship just narrated.
Right.
The two petitioners and Patrick.
Right.
Patrick, my lord, is a shareholder of a family company called Bauer, which is the respondent in the other petition, which is the joint venture partner. This joint venture, my lord, was formed only to make supplies to Zonta Infratech, to the petitioner.
And Bauer is the company of which Patrick is a shareholder in his individual.
Yes, and director.
So, insofar as what the way we understand it is, in the first case,
yes,
which is actually the second case, 32.1,
yes,
there's an arbitration agreement between Zonta Holdings and Bauer, the German companies. We'll appoint an arbitrator there.
Please, my lord.
In the second case, we'll appoint an arbitrator as between Zonta Infra, Zonta Holdings, and Patrick.
Yes.
We will appoint the same arbitrator in both cases.
I'm grateful.
You can apply it before the arbitrator for impleading Bauer.
Yes.
Because look, Bauer it's a family company. You can move that because that's consistent with our judgment in the group of companies doctrine.
But I must just clarify, my lord.
Now, sort of going behind the veil and,
But anyway, the tribunal has to decide it, whether I have to impede them or they stand impeded and get. But may I just make one clarification so I'm not...
Protect your client. We'll protect your client. Right now, in the second matter, or really the first matter, we'll appoint an arbitrator in the dispute between Zonta and Patrick. And the issue as to whether any other party should be impleaded, we'll leave open for the to be urged before the arbitrator. So that will protect your client. Today, because otherwise we'll have to decide the issue. We'll have to decide your defense, which will take us at least another hour, because we'll have to look at facts. We'll have to see what was the conduct of the parties, whether there was a representation that you would be buying, that you were the person standing behind.
Let the arbitrator decide that.
Yeah, that's better. So now tell
May I make just one clarification?
so many of these cases, we have been appointing, young junior counsel in our court as arbitrators because, they're commercially wise and, we can tell us now. You want because of this, he says his claim is 180 crores. Should we appoint a former judge? Do you want a counsel?
Would your lordship consider, I know the seat is Bangalore. I think most of the parties are Bangalore. So when your lordships are considering...
I am in Germany. Whether it's Bangalore or anywhere else.
Yeah.
So then should we refer it to the Bangalore Arbitration Center?
Let them appoint.
There's a Bangalore Arbitration Center.
Let them appoint.
Of the money which was lent to them.
Nothing on that.
Please clarify.
Yes.
Please clarify.
We'll say.
Find out what the petition is holding.
What we'll do is that, having due regard to the nature of the claim, that's a little order. Two arbitration petitions have been instituted under Section 11 of the Arbitration and Conciliation Act 1996. Arbitration petition 47 of 2023, correct me if I'm wrong in any information. Arbitration petition number 47 of 2023 it pertains to a joint venture, arises from a joint venture agreement dated 2 June 2016 between Zonta Holdings and Bauer. All right?
It's now called Zion Holdings. Zonta Holdings changed its name.
Is it Zonta Holdings Limited or Zonta
Private Limited, now called Zion.
Zonta Holdings Private Limited, into brackets, now called
Zion Holdings Private.
Can you just give that?
I'll do that.
Just ask the juniors to. So that
And it's also Bauer.
And Bauer GmbH. Stop. The arbitration agreement is contained in clause 14 of the JVA. Full stop. Arbitration petition, the arbitration agreement is not in dispute. Arbitration petition 49 of 2000 the arbitration petition 49 of 2023 relates to an equity subscription and debt financing agreement into brackets ESDF agreement dated 21 February 2017. Full stop. The arbitration agreement, the ESDF agreement is between Zonta Infra and Zonta Holdings.
Yes. We'll give your lordship the full name. Yes, we'll give your lordship the full name. But it's Zonta Infratech and Zonta Holdings.
It's Zonta Infratech and Zonta Holdings Private Limited. And Mr. Patrick Bauer on the other hand. Full stop. The arbitration agreement is contained in clause 15.6 of the ESDF. Full stop. The respondents have adverted to a settlement, an alleged settlement dated 6 October 2022, which according to the petitioners was obtained, which according to the petitioners is vitiated by coercion. Full stop. In both the cases, the existence of the arbitration agreement is not in dispute. Full stop. However, in arbitration petition 49 of 2023, apart from Mr. Patrick Bauer, there are how many other parties? Two other parties who contest, who dispute the maintainability of an arbitration against them on the ground that they are not parties to the contract. Full stop. With this backdrop of the dispute, we are of the considered view that the arbitration petitions under Section 11 of the Arbitration and Conciliation Act 1996 can be dealt with by constituting an arbitral tribunal comprising of a sole arbitrator. Full stop. It has been agreed that instead, in place of a three-member arbitral tribunal, the appointment of a sole arbitrator would subserve the ends of justice. Full stop. In that view of the matter, we appoint Mr. Justice A.S. Bopanna, former judge of the Supreme Court, as sole arbitrator. Full stop. The arbitrator shall fix his fees in consultation with the parties. Full stop. However, it needs to be clarified that the reference to arbitration in arbitration petition 49 of 2023 shall be as between the petitioner and the first respondent.
Second respondent.
You are the second respondent or the
First and second. Patrick Bauer is the respondent too.
You are the second respondent between the petitioners and the second respondent into brackets Patrick Bauer. The issue as to whether any other parties are liable to be impleaded as parties to the arbitration agreement is left open to be determined by the arbitral tribunal.
Your lordship may clarify, your lordships have expressed no opinion.
Obviously, they have not expressed.
But similarly, if your lordship observes something, it affects parties. Of course, the criminal proceedings are not impacted by an arbitration.
The standard is, this is a private tribunal, that's a criminal proceeding. The standard of proof is different, the nature of investigation is different. We don't have
Just one request, and that is important.
Yeah.
The disputes are only arising out of these two agreements, because what they've tried to do is they are trying to cloud the second petition, which is 49, to also include SPLC, where there is no arbitration clause. So please specify that it's only with respect to these two, because my case in SPLC is that they've siphoned off funds.
The dispute, the disputes which have been referred to arbitration,
respondent in this matter. There are efforts of settlement being made with the petitioner, your lordship, and We have agreed that the matter may be referred to mediation.
Mediation or? Very well, Your Lordship. Nothing has happened for years, but we can try mediation.
Right. Parties have agreed at this stage to a mediation under the auspices of the Mediation Center of the Supreme Court.
Yes, Lordship.
Yes, Your Lordship.
They shall appear before the Mediation Center at 2 p.m. on next
Any day, Lordship.
week.
All parties are here, so foreign parties are there, so we are representing them.
All right. Next week.
Next week.
Yes,
What we can do is we can appoint an arbitrator. We can say party shall first go to mediation. If mediation doesn't succeed by 31st of August, then the arbitrator may enter upon references. All right, that's what we'll do.
Deeply obliged.
The arbitration agreement between how much is the claim?
This is a claim of possession first. This is a commercial property to be delivered. There are mean profits as well. So that is to be determined.
So whom should we appoint?
May I suggest Justice Bhatt in this case, Lordship?
All right, we'll appoint Justice Ravindra Bhatt. In view of the arbitration agreement between the parties, it has been agreed that a sole arbitrator may be appointed under the Arbitration and Conciliation Act 1996. Full stop. Shri Justice Ravindra Bhatt, former judge of the Supreme Court, shall accordingly stand appointed as sole arbitrator. Full stop. Since parties have expressed the desire to explore the possibility of a mediated settlement, they shall appear before the Mediation Center of the Supreme Court at 2 p.m. on Tuesday. If the mediation proceedings, if no settlement is arrived at in mediation by 31 August 2024, the arbitrator shall be at liberty to enter upon the reference and proceed thereafter. Stop the arbitration petitions accordingly disposed of. The arbitrator would be at liberty to fix his fees in consultation with the parties. Then, Section 4.
Deeply obliged.
Please, my lord, I'm appearing for the respondent. My lord, the advocate on record, Mr. Das, has taken ill. We've informed the other side also. We only seek 2 weeks to file our reply.
Then file the reply.
The next Monday is possible.
Keep it on a particular day.
Please.
My lord, I appear for the petitioner in item 35, my lord. This is a matter, my lord, where I have invoked the company doctrine, my lord. But I have been served with the reply of the respondent number 1 only day for yesterday. I am seeking to file a rejoinder, my lord, to bring on record documents showing conduct and commonality.
Are you a party to the arbitration agreement?
I am, my lords. I am respondent number 1. My friend is for respondent number 2.
Who is not a party?
Not a party.
So what we can do is, subject to your agreeing, we can appoint an arbitrator.
But I have some other objections, subject of course to
any serious objection.
Because the issue here is, they were to obtain these subscriptions. We subsequently found, as we tightened our procedures, 17,000 millards fake IDs. So there are criminal complaints also filed. My concern is, A, there is criminality. Now the purpose of this arbitration is perhaps not his 5.5 crores or whatever he wants. Because now he will say that the matter has been referred to arbitration. Disputes are purely civil in nature. You don't examine whether there is cyber fraud or impersonation, etc.
But that's a matter for the arbitrator because you are Maxter, right?
Yes, no.
And you appoint the petitioner as a distribution partner.
Correct, no.
So, according to you, there were certain fake IDs.
Yes, no.
Right, which he generated.
Yes.
But that's a matter of, that's also.
No, that could be I understand, that could be whether some money is owed or not owed. But my concern is this. If there's criminality, in Vijay Drolia, Lords, in one paragraph, the Lordship said, if there's criminality, my lord, at least there may be a case not to refer.
That's all right.
When Lordship will only protect me to the extent, my lord, that my concern is this, that they will say now the court has referred the matter to arbitration. This is a case for quashing. I have the civil disputes and not any number of judgments. The Lordships have said, on civil nature, there will not be a prosecution.
You filed an FIR.
We have filed complaints, my lord, they're still under investigation.
My lord, may I respond to that? Firstly, my lord, my arbitration petition is prior in time. 2, my lord, they have filed a criminal complaint before Gurgaon court, my lord, where there is a closure. So therefore, I don't know
what is complaint in Chennai also that is pending.
But once there is a closure in Gurgaon, my lord, they run
on uninfluenced.
Civil
The 2 will protect. We'll say that R2 He may move an application before the arbitrator, which will keep open for the arbitrator to decide in view of our judgment.
It feels not only para 169 of Cox and King's.
Of Cox and King's judgment, yeah.
Your lordships have to make a prima facie opinion about not whether to even.
We are not referring you to arbitration at all.
That's right, lordships.
That's why we are doing that. So, how much is the claim?
Well, claimed in their notice 5.5 crores, my lord.
The total claim and counterclaim is about 18 crores plus damages, my lord.
So, should we appoint a counsel as an arbitrator?
Of course, we had suggested some retired judges. I can hand over the list, but I leave it to your lordship.
May I suggest Justice Sen or Justice Bhatt, my lord? Or Justice Banumati?
The claim is not very large.
It's a small claim, it's just 5 crores.
I mean, it's not in any particular order of preference, my lord. It's just.
My lord, or perhaps a judge from the High Court of Delhi, my lord.
That's what we have suggested.
There is an arbitration agreement between the parties. Full stop. There's an arbitration agreement between the petitioner and the first respondent. Full stop. Hence, the disputes and differences between the petitioner and the first respondent are referred to the. It has been agreed that that a reference to a sole arbitrator may be made. Full stop. The disputes and differences between the petitioner and the first respondent are referred to the sole are referred to Dr. S. Muralidhar, former Chief Justice of the High Court of Orissa, as a senior counsel, and formerly Chief Justice of the High Court of Orissa as sole arbitrator under the Arbitration and Conciliation Act 1996. Full stop. As regards the second respondent, it would be open to the petitioner to move an appropriate application before the sole arbitrator for impediment, which may be decided in terms of the governing provisions of law. So the arbitrator may fix his fees in consultation with the parties. The arbitration petition.
My request on that it should not be construed as any opinion as far as any criminal proceedings that I have initiated.
Reference to arbitration, the reference to arbitration of the disputes under the contract will not be construed as any expression by this court on issues which may arise in the criminal proceedings.
I'm very clear. And on the merits of the implement also. I'm sorry to point this out.
No, absolutely not. We have not. Otherwise, we would have implemented you. The very fact that we have not implemented you means we have not expressed any opinion.
Yeah? I'm very clear.
Now, Parmeshwar, which are the states which have not implemented our judgment?
I just circulated a note in I have a note minutes. I have a very detailed note in this.
You have the note, yeah?
Yes. The note in this package.
Mr. Solicitor, that is the updated position you have now of who has...
Yes, I have the updated position till yesterday night. Till yesterday night, we were served affidavits and compliance. But I just wanted to bring to your lordship notice, this is the 6th or 7th time the lordships are asking them to pay up allowances and pay ballots. Your lordships, kindly see the major reporters. Let me just point out from page 6 onwards. But that's a number of high courts have deducted TDS on allowances, ballots. So that issue I'll come to. But your lordships,
because allowances, you can't deduct TDS
at all. Protected under section 192 and section 1014 of the Income Tax Act completely, because it is for money spent that allowances are paid. So there's no question of TDS, but I'll come to that a little later. But your lordships, kindly see from page 6, Ilhabad. In 6 minutes. The Lordship sees, so far as Yellabad is concerned, my lords, there is more or less compliance. I shouldn't take. I think there are minor difficulties which will get ironed out, my lords. So far as Andhra Pradesh is concerned, there is substantial non-compliance. I have marked substantial non-compliance. Your Lordship sees the last two columns. So far as payment of revised allowances are concerned and payment of arrears of allowances, my lords, most judicial officers have not received it. Most judicial officers haven't received.
Fixed, my lords, we just for payment of arrears.
Firstly, I just wanted to bring to your lordship's attention the 7th time your lordships are extending time. Repeatedly, your lordship have recounted all those orders in the first 3 parts of my notice. At best, my lords, August 15. There are states which have moved IAS asking for 6 months, 2 years. Orissa on its own is 15th August. 15th August. All states, my lords.
A note has been submitted by Mr. K. Parmeshwar, the amicus curiae, indicating the status of compliance with the orders passed by this court on.
My lords, 3 orders, my lords, 27/7/2022.
27 July 2022 to July 2023.
19th May 23 and 4th January 24.
19 May 2023
and 4th January 24.
Then there's 23rd November also, no?
That is only for extension, my lords. Your lordships again. For the substantial order, your lordships.
And 4th January 2024. Full stop. Those seven opportunities, 7, right, have been granted by this court to the states to comply. It appears that full compliance has not been effected and several states are in default. Full stop. The note highlights the states in default and we will deal with them. Full stop. They are dealt with CRETIM, Poland, Andhra Pradesh, the Learned Standing Council, Standing Council, Standing Council. Ms. Prerna Singh, appearing for the state of Andhra Pradesh, states that she has instructions to the effect that the payments which are to be made to the judicial officers have been made.
Whatever could be uploaded has been made.
Whatever could be uploaded.
Portal. There is a portal for the uploading of bills of arrears, which is the main. If my lords will see the last column, that is the main non-compliance that has been attributed to us.
Ms. Prerna Singh, Learned Standing Council for the state of Andhra Pradesh, Learned Council for the state of Andhra Pradesh states that the portal through which bills were to be uploaded that payments have been made to the extent to which bills were uploaded on the portal, on the web portal, which was opened for that purpose. Full stop. Should we say, Mr. Parmeshwar, that this may be verified?
There's clearly non-compliance because the judicial officer spoke to me yesterday night. Number of judicial, the All India Judges Association is also here, my lords. There is no doubt, my lords, most states have been lackadaisical.
All right. We will say that, on the other hand, both the amicus curiae and the All India Judges Association, which is represented in these proceedings, have categorically stated that that full compliance has not been effected. Full stop. We direct that meeting be held. Meeting be held by Monday between the Registrar General of the High Court of Andhra Pradesh, the Chief Secretary.
Plus, would your lordship then direct that committee to meet? Your lordship said institutionalized it, and that committee, all of them, all the relevant people are part of that committee.
Convened by the committee appointed by this court in its order dated
4th January 2024.
4th January 2024.
SCDJ.
What do we call it?
CSCDJ.
The CSCDJ. Within preferably on Tuesday, we say it's a little time. Preferably on Tuesday next, so that in case compliance is still to be effected, it is completed no later than by 15 August 2015. Full stop. A compliance affidavit shall be first shared with the CSCDJ and thereafter filed before this court, indicating compliance, failing which this court will be constrained to adopt contempt proceeding against the officers of the state if full compliance has not been effected.
Then Bombay, my lords. The lordship sees Bombay at page 8, my lords. Most of it is in substantial compliance except for the part so far as TDS is concerned. On TDS, the lordships will pass an omnibus order on all high courts, my lords. Would your lordships only see, this is unfortunately, my lords, your lordships will see, if your lordships, the second last column. What they've been doing is many state governments have again tinkered with your lordship's order on allowances. After your lordship's order, there's no question of the state governments now saying that this is not permissible under our rules. We will not allow it. Mobile handsets can't be. Your lordships, remember during the hearing also this question on mobile handsets. ACs,
that we'll deal with separately.
Furniture ACs. So an omnibus order on the count that there's no question of now deviation from your lordships.
That we'll deal with.
So far as Bombay is concerned, only this, because they have now said we'll take a call on mobile handsets and AC and furniture.
That we will.
Otherwise, there has been substantial compliance so far as Bombay is concerned. They have taken effective steps.
Which are the states which are not compliant?
Calcutta. West Bengal has taken IA for extension of time with us.
We'll give you time till 15th of August to comply by 15th of August.
I'm only requesting some more time. It was 15th of August, so I don't want to come back, seek further time.
It has to be, because 7 opportunities have been granted to us. All states have paid. I mean, how can West Bengal say we'll not? Then you say that, look, then you can sit at home, will not take any work from judicial officers. They're all working there.
May I say this? It's only pertaining to arrears, but rest of the things have been implemented pertaining to arrears.
Telangana state, my lord.
Not compliant, because in the amicus report it says virtually compliant.
How much have you paid?
They will not, none of the states are very smart. None of them will say how many judicial officers are there. They will say we have complied.
One officer come clear on this one. My revenue laws. Because
I just got giving space.
State of West Bengal, there has been non-compliance by the state of West Bengal with the orders of this court. Full stop. The time has been 1 year's time is sought for effecting compliance, which is unreasonable. Full stop. We grant time for full compliance till 15 August 2024. We keep the matter for reporting compliance on 20 August. We'll keep the matter. We extend time for compliance until 20 August 2024. Full stop. The proceedings shall be listed on 23 August 2024, on which date both the Chief Secretary and the Finance Secretary for the state of West Bengal shall remain present before the court with affidavits indicating compliance.
All states, just bring to your lordship's notice, all state government and union government wanted with the 16, that was the pay commission. We are on the threshold of the next pay commission 2026, and yet our judicial officers after 8 years, 9 years haven't received it. It's not as if it's a
different case for judicial officers. Most of these recommendations are at par with state government and union officers.
We are constrained to pass the above order. We are usually circumspect in directing the personal presence of the officers of the state. Full stop. However, this is a situation where the officers, the bureaucracy has received the revision of their pay scales and other allowances with effect from 1 January 2016. Full stop. Judicial officers are yet to receive the revision, the revised pay scales and allowances. So the arrears which are due to them in terms of the SNJPC, so 8 years have elapsed. Full stop. Despite, as we have already noted, despite sufficient opportunities, there has been non-compliance. Full stop. It is in this backdrop that we have been compelled to pass the above order. So then,
instead of bureaucracy, lordships may consider administrative officers in the executive.
Bureaucracy, administrative officers in the executive.
It's a better word. That's
better.
Manoj, just one thing, Manoj may not say that state of West Bengal has not complied. Manoj may kindly say partially complied, as the amicus has stated, because it seems that we have.
But you have not told us how much you have paid. You tell us how much you have paid. Then you would have.
I'll come back on this and just.
Anyway, you now you think all right. Which is the next one now?
Just only one thing. If just in case we are not complying by 20th, then Manoj may require the presence.
Now they have to remain present with an affidavit of compliance. Otherwise, we'll send them marching from here. Yes.
Chhattisgarh also concern is the allowances, Manoj. But if your lordship, tax,
Tax will pass a separate order.
Again, the same thing in Chhattisgarh also. They will say we are considering whether we should grant those allowances. I don't understand those DOs. With all due respect, Manoj, after there is a Supreme Court judgment, the subject matter of all those DOs mentions the Supreme Court judgment of 4th January 24 and then says we will now consider whether we must grant those allowances.
Where is that in your note?
Your lordships kindly see page 10, Chhattisgarh Millers. Your lordships will see committee is considering upon the mode of payment of concurrent charge allowance. State has issued geo-dated so and so sanctioning increments on acquiring higher qualification, but no date has been mentioned. All that is clear in your lordship's judgment. There is no question of now saying that we will deviate from your lordship's judgment. And your lordship
State of Chhattisgarh, the geo issued by the state
and out of 20, only 11 have been sanctioned.
And full stop. Out of 20 allowances, only 11 allowances have been sanctioned. Full stop. The state, the conduct of the state of Chhattisgarh is plainly unacceptable. Full stop. Despite 7 opportunities, 7 is there also, no?
Everywhere.
Despite 7 opportunities, the judgments of this court have not been complied with. We direct the personal presence of the Chief Secretary and the Finance Secretary of the state of Chhattisgarh before this court on 20 August 2024. 20 August bola tha na? 23 August 2024, together with affidavits of compliance, failing which the court would be constrained to take recourse to the exercise of its contempt. All right, that's Chhattisgarh. Then full compliance by the 23rd. Yes, and the Chief Secretary and Finance Secretary have to be personally present in this court on that day. Now we are not going to say that if you comply with, then you need not be present, because then they'll not comply with. Only if we now direct presence that they will comply with. We now know how to extract compliance with the order. Yes. We are not going to send them to jail if they comply, but they have to be present here and tell us that they have complied. Nothing doing now. Yes. Which is the next?
Delhi, Manoj, page 12, no allowances, no arrears of allowances have been paid.
Delhi,
no allowances, no arrears of allowances. Last quarter.
The NCTD, the government of NCTD has not complied with the orders passed by this court. Full stop. No case for extension has been made out. Full stop. We therefore direct full compliance with the orders of this court by 14 August, by 20 August 2023. The Chief Secretary and the Finance Secretary of DNCTD shall remain personally present before this court on 23 August 2023, together with affidavits of compliance for the purpose of reporting compliance, failing which the court would be constrained to take recourse to the exercise of its contempt jurisdiction. Then,
Assam, no compliance. They moved an IA for extension saying citing floods because there was no floods in the year of.
File an affidavit also. Also, we have issued a notification. So far as 14 heads are concerned, Lordship, we have issued the notification, the report, because it came later, Lordship. That was the only thing, Lordship. The time, Lordship, that is being taken, Lordship, is we are really, Lordship, now facing disaster.
the counsel appearing on behalf of the state of Assam states that a notification has now been issued for the payment of 14 allowances.
14 allowances.
Full stop.
Not 7, Lordship, 6. Lordship said 7.
There has to be full compliance with the orders of this court. Full stop. This court is not inclined to grant any further extension of time or exemption to the state. Full stop. The Chief Secretary and the Finance Secretary of the state of Assam shall remain personally present before this court on 23. ऊपर जो लिखा था ना 20th August and 23 August. Same order.
Lordship, our situation is a bit critical, Lordship. It's because of disaster situation.
Yes, these are people who are people who are working in service.
Yes,
you have to pay them now.
Lordship, may I just submit, Lordship? Lordship has given time to the other state till 15th of August.
20th August we have given you. We have given you time until 20th of August, paid by 20th of August, and asked the Chief Secretary and Finance Secretary to be in court on the 23rd of August to report that they have complied. Then we will we'll put an end to the matter.
That may be exempted, Lordship. We are in a genuine situation.
Then I don't know what will happen. Then there will be another application for extension. Once we say this, the money will come.
Lordship, we are in a peculiar disaster situation, Lordship. We are facing it, Lordship, in the state. Lordship, everyone is.
How much is the amount that you have to pay?
Lordship, I suppose it is more than 100 crores, Lordship. More than it will be for a state like Northeast, and we are facing floods, Lordship. It is the third round of floods. It is the third round of floods.
Ask the government of India to pay you. They'll pay you from some other help. Yes.
Lordship, Lordship, our case, Lordship, may kindly consider.
No state.
The other states will not come out with this situation, Lordship.
No.
Our situation is a bit critical, Lordship.
We'll not do anything like that.
Consider it on the next day, Lordship. On 23rd.
To remain, we'll see if
Lordship, 23rd, if we don't show any progress, Lordship, kindly consider.
On the 23rd, if you are not able to pay, let the Chief Secretary and Finance Secretary come here and tell us why you can't pay. We'll consider your request. But they must remain first.
Lordship, that's what Lordship, I was only requesting, Lordship. Kindly pass that order on 23rd, Lordship. If we don't do, Lordship, we are in a situation, Lordship. We are in a critical situation, Lordship.
Tell us when did your
otherwise I would not have pressed it, Lordship.
Tell us from what date did you revise the pay scales of your administrative officers?
That we have complied, Lordship.
From which day?
So far as the administrative officers. So far as the SNJPC, Lordship, we have complied with everything, Lordship.
No.
That I can't offhand tell, Lordship, from which
When have they got you? Please tell you. 1st of January 2016.
Lordship, we have complied with every direction of the SNJPC, Lordship. We have complied with everything.
Point. We'll pay the state civil service officers. Judicial officers are not our.
Lordship, I am not making a legal argument, Lordship. I am not making a legal argument. It's on a different criteria, Lordship. So only
who else, Mr. Parmeshwar?
So far as Guwahati High Court is concerned, my lord, Arunachal, Nagaland and Mizoram, my lord, notifications are there, but release of funds is, according to the last affidavits, not comes. So your lordship may direct the same direction so far as Arunachal, Nagaland and Mizoram.
The same direction shall apply to the states of Arunachal, Nagaland and Mizoram. Then,
so I appear for the state of Nagaland. All the information has been collated, is scrutinized, it's just pending with the finance department, your lordship. There has been compliance. We've accepted all the allowances, your lordship. Kindly give us time, and your lordship may not.
Until 20th of August.
Insofar as the presence of the chief secretary and the
we have to secure presence.
Because there has been substantial compliance. It's
yes.
just the dispersal of funds.
The compliant come here, come visit Delhi once, yes.
Gujarat, I'm now told there is substantial compliance except TDS.
TDS. That will just pass an omnibus order.
Himachal Pradesh, the affidavit doesn't give us any information, fortunately. So far as
what is the position in Himachal?
Even the
State of Himachal Pradesh में ऐसा लिखिए, the Chief Secretary and Finance Secretary of the State of Himachal Pradesh shall file a joint affidavit indicating compliance. Full stop. Since as of date, who's appearing for the State of Himachal Pradesh? Where is he? Who's appearing for the State of Himachal Pradesh? The Learned Counsel for the State of Himachal Pradesh is absent when the case is taken up. Full stop. The Chief Secretary and Finance Secretary of the State of Himachal Pradesh shall personally remain present. Will be same order, huh? Let them come. Yes. Then?
Jammu, Kashmir and Ladakh, no money is paid for.
Jammu and Kashmir and Ladakh, same order as
complete non-compliance.
My lord, I appear for UT of Ladakh. May I assist your lords in case of the UT of Ladakh, my lord?
Yes.
My lord, in case of UT of Ladakh, all the funds are available with the two district judges, my lords, and the two district judges are the drawing and dispersing officers. The funds have been provided, my lords. The dispersal is with lot of district judges, my lords. My lord, may I have my compliance affidavit?
Regards the Union Territory of Ladakh, Mr. Piyush Beriwal, right?
Yes, my lords.
Learned Counsel states that the two district judges are drawing and disbursing officers, and the funds have been placed at their disposal.
Yes, my lords. My lords, we have also filed an affidavit, my lords.
All right. So Ladakh ke liye don't pass any order of presence.
Much obliged.
Jharkhand also same thing, but there's no information on areas of allowances.
Jharkhand? Have payments been completed? Have you paid all the 20 allowances? Then same order for Jharkhand. Ask the Chief Secretary and Finance Secretary to remain present. Time until 20th. Yes, then?
Karnataka is not a concern with us. Karnataka is not concerned. Kerala, my lords, not paid. They have moved an application for extension. They have not
Kerala, pay. That's all right. You ask the Chief Secretary and Finance Secretary to remain present. Kerala, the same order. Compliance by 20th, personal presence on the 23rd. 20th of August and personal presence on the 23rd. Yes.
Unless Madhya Pradesh also same thing. SOP has been made by the committee, your lordships constituted, but no disbursement.
Madhya Pradesh is the same. Madhya Pradesh, same order. Then?
Tamil Nadu, my lords, not a single paisa.
Tamil Nadu?
Grave default.
Same order.
Manipur had a problem, and they moved an IAO.
With respect to the pay and pension, everything has been paid. The allowances, they have been approved. The prospective payment of the allowances have started, and I have got a payslip from the respective JDOs also. Because with respect to the areas of pay, that is the only problem that we have. Because we were seeking a little bit of more time for extension.
How much do you have to pay?
This is about 24 crores, and the state is running into some deficit.
Yeah, get it from the Union of India. Same order for Manipur. Yeah.
Can it be a little?
20th August, now 20th August. It's uniform for everybody, yes.
Meghalaya also.
Meghalaya?
Same thing.
Same order, Meghalaya.
It's Odisha, my lords.
You're from Meghalaya?
Status was previous to end of financial year.
So 20th August. 20th August, ask the Chief Secretary. If you have paid, mention the matter earlier and tell us we have paid, we will exempt your Chief Secretary. Otherwise, we have to be present here.
But so far as Odisha Orissa is concerned, 6 allowances they decided not to do.
Orissa
And so far as the arrears is concerned, they themselves decided that they will pay it over 6 or 7 installments.
Same order.
Not as far as the
एक और लिख लीजिए. 6 allowances have yet to be paid.
Not as far as state Orissa is concerned, the resolution of the finance department has come in on the 16th of March 2024, and the law and the home department have submitted the proposal in the ensuing session for release of the funds in the Orissa legislature. That's the instruction which I made.
Learned Counsel for the state of Orissa states that the
resolution of the finance department has been issued on 16/3/2024.
That the resolution of the finance department was issued on 16 March 24.
And the law and home department have submitted the proposal for making the budget provision of the NP.
The law and home department have submitted proposals for ensuring payment.
The budget provision.
For making a budget provision in the ensuing budget session.
Ensuing Orissa legislature.
20th August, we are keeping compliant and ask the Chief Secretary and Finance Secretary to remain present.
Very well. Very great.
Yes.
So far as Patna is concerned, I am now told, yesterday evening I received a note saying that they have started disbursal of all the allowances. But the last affidavit which was filed said that allowances have not been paid. Now this is paid.
Yes, then.
Punjab and Haryana High Court, again, the committee filed an affidavit.
Bihar, as a Learned Counsel for the state of Bihar states that an amount of rupees 122 crores has been transferred to the Law and Judicial Department, right? And the payments are being made in full compliance with the order of this court. Then
Punjab and Haryana, allowances arrears have not been complied with, and allowances future payments are partial compliance. We'll also see the last two columns.
So same order for state of Punjab, ऐसा लिख लीजिए. Same order, we say full compliance we should.
There is an issue with respect to state of Punjab and Haryana. The matter is pending before the full bench of the High Court. Allowances, that's why they were not ready. The state has complied with it. You'll also see the note as well. There is an SLP pending before this court, pursuant to which the High Court has called its head and not released and not granted this approval. That's relevance. It's relevance.
So except for super time,
that we have been done, Your Lordship, for the state of Punjab. For the state of Punjab, we have done, Your Lordship. Only that matter is pending before the High Court. Page 1168.
all right. State of Punjab के लिए ऐसा लिख लिया. Which where is page Punjab is
Page
saying?
1168, Your Lordship.
Because that's in respect of, that's not allowances, that's only selective time and superscale. That's litigated between the judicial officers, therefore that full which I've examined.
What about the allowances? Have you paid the allowances?
Your Lordship, we'll place that on record, Your Lordship.
Sorry?
We have released the allowances 11th April 23, Your Lordship.
We pass the same order. If you have, come back to us, file an IA before the next date of listing. We will and give it to Mr. Parmeshwar. He'll verify it. We'll delete the requirement of the presence of your chief.
But to that effect, Your Lordship.
So you first ensure that the full payment is made. File an affidavit. Give it to Mr. Parmeshwar. Come here and mention it. We will exempt appearance.
Rajasthan, same order as the others. No information has been provided to this court in the contract.
Rajasthan. All right. Anybody else?
I'm sorry, my lord. I was just trying to say something, but I was not unmuted. Unmuted, my lord. For Delhi, my lord.
Yes, for Delhi.
The problem for Delhi, I am appearing for Delhi. Yes, my lord. We are waiting for the approval of the central government because we have we can make payment only once the central government.
We are not concerned with that. You sort it out with the central government. We want payment to be made. Yes.
The other order continues.
But central government has filed review petition. This
Haryana as High Court because the
Haryana
the other orders continue because they have not paid up the allowances.
Haryana का the same order will continue.
And Punjab is on.
पंजाब का हमने order pass किया था.
Telangana state में लगा. Rajasthan. Kindly consider this that central government has filed review petition.
Punjab and Haryana we have passed the same order. Punjab, Haryana the same order of personal presence.
Fine.
provided if they come back here and file an IA saying that you have paid, then you can tell us. We will. You can mention, Parmeshwar, that these states have been. You can come and mention so that.
So far as Rajasthan, Sikkim, Tripura, and Uttarakhand are concerned, Rajasthan, Sikkim, and Tripura the same order. Allowances have not been paid.
Rajasthan, Sikkim, and Tripura same order. And
Telangana has complied. Uttarakhand the only issue is TDS. Because on TDS, I just once.
As for Sikkim, may I make one submission, my lord? May I request for a similar indulgence as the previous council? Once I file the updated status of allowances, may I make a request for exemption for appearance, as my lords have permitted the previous councils for other states? Because I'll get the updated status and ensure that the allowances are paid.
Let them Let them
similar request.
Yes. Sorry.
Very well.
TDS is concerned, would you want to pass an omnibus order saying wherever the exemptions are from the Income Tax Act, so far as allowances are concerned, no TDS should be cut, because there's no point in going
We say wherever exemptions are wherever exemptions are available under the provisions of the Income Tax Act 1961 from the deduction of TDS on allowances, the state government shall ensure that no deduction of TDS is made.
And wherever deducted, my lord will give them time till September to return that, because then this is every deduction. You'll have to go back, because this is 1 minute. The state government is deducted so that
wherever the state governments have wrongly deducted the TDS, they shall refund the amount.
मोटोराइजर 50 अल्ट्रा ने फ्लिप फोन्स की दुनिया को ही फ्लिप कर दिया है. इट इज द मोस्ट इंटेलिजेंट फ्लिप फोन. इसमें है गूगल जेमिनाई, गूगल फोटोज के AI फीचर्स और बहुत सारी एप्स सपोर्टेड ऑन द मैसिव एक्सटर्नल डिस्प्ले. 4 इंच का कवर डिस्प्ले आता है जो सबसे बड़ा है.
कैमरा अमेजिंग क्वालिटी का है. ये स्मार्टफोन बहुत ही ड्यूरेबल है. IP-X8 अंडर वाटर प्रोटेक्शन गोरिल्ला ग्लास विक्टिस लगा हुआ है.
प्लस इसमें है Qualcomm Snapdragon 8S Gen 3. Moto Razr 50 Ultra is truly a standout flip phone.
Motorola Razr 50 Ultra. Flip the script.
Hello Moto.
पीठ दर्द के लिए कुछ दो ना भाई.
ये चलेगा.
लॉलीपॉप. ये इतना मीठा है कि थोड़ी देर के लिए आप दर्द भूल जाएंगे. तो इससे दर्द थोड़ी मिटेगा.
अगर दर्द को मिटाना है तो ओमनी जेल मांगो ना. इसका डाइक्लोफेनेक फॉर्मूला अंदर तक जाए और जड़ से दर्द को मिटाए. ओमनी जेल, इंडिया का नंबर 1 पेन रिकवरी जेल.
Monday, you can tell him what the issue is, so that then we can clarify.
Just housekeeping, sorry, sir.
Yes.
So that all those contents in the IS can be disposed of.
For Telangana state, no complaints. For Telangana state.
Where are they?
Page 26 of my.
Yes, there are 8 contempt petitions. Yes. Page 26 को serial numbers 1 to 6 IS stand disposed of.
Similarly, one of those 8 points. Others dated 22. Those contempt petitions.
Telangana state, my lord. Telangana state. 45.
There are a number of IAS and petitions for intervention. Prior to your lordship, those also can go.
All serial number 1 to 17. Serial number 1 to 17 का जो पेज 27 और 28 को है वो भी डिस्क्लोज.
Your lordships may mention on
So what we'll do is
your lordship on the lordship with your lordship's permission, Millers, may
in the afternoon today the Omni date.
I'll just log in.
The matters on Monday, including NEET, also will take up on Monday.
may have your lordship's time for just half a minute. Can I have the attention of the court for just half a minute?
So we'll take up NEET tomorrow first on board, and then we'll proceed. Mr.
May I have your lordship's attention for a minute?
That's serial number.
38, my lord.
38, kal rakh do. 38.
Lordship and lordship request, my lord. Maharaj, if 38 can be on Monday, my lords, we need date instruction and we'll place something on record also, my lords.
Mr. Rajkumar, yesterday the solicitor was also saying that he will require a little time on Monday.
But the problem is this, not every day one order is being passed. Again, today has been passed.
Yes, that on record, my lord. Nothing first has been passed, my lord.
What is being happening is, my lord, as I mentioned yesterday, not about what happened. Then on 9th July, they said, no, that order is withdrawn. Then on 10th again, yes.
But we take it up on Monday instead of tomorrow.
Sorry, sir.
Monday instead of tomorrow. He will also be able to file a short affidavit.
What affidavit? They are on KBS.
Because yesterday only they have filed an affidavit, my lord. We have received that affidavit.
All right, tomorrow. I have to rise tomorrow.
My lord, could need be on Monday, my lord? Could need be on Monday, my lord?
I only request for tomorrow because it's a condition where your lodges, despite your lodges order on option purchase.
Yes. We know that, yes. But Brother Pardiwala's judgment, yes.
My lord, they need.
Whereas we are all here, wherever the lordship
Instead of Monday, we were planning to keep that on Monday. We take it up on Friday.
My lord,
that is Friday week.
the NEET matters may be.
They've given us a copy, but difficult is the copy doesn't open.
I didn't against the NEET matters may be kept on Monday.
It matter will again.
When were they sent to these cities?
Yes, please.
When were they sent to these cities?
Approximately about 5 seconds.
We don't want to tell us the precise dates.
I'll get the exact dates.
When were they sent? How were they sent to those cities?
Yes, please. I'll get the dates. Bihar police
And were they lodged in the State Bank and Canara Bank in each of these cities, or what happened?
each of the cities minutes they are lodged with the custodians who are minutes Canara Bank and State Bank.
So we want to know on what date were the question papers sent? Where were they? When were they? When the question papers were prepared?
Yes, please.
Right. Question papers are prepared by one person or more than one person?
Group of experts. Question papers are prepared at the headquarters.
Where are the headquarters? Delhi.
In Delhi.
So two sets are prepared by two different groups or one group?
It's, by the same group. First,
one second.
The same group of experts minutes there's two different sets of question papers.
At the headquarters?
Yes.
After they are prepared, they are given to the NTA?
Yes, please.
Right. Now, tell us when did the group of persons conduct the prepare the question papers and give you the question papers?
Dates. I'll get the date.
Right. We want to know what was the date on which these question papers were prepared and given to you.
Yes.
Point one.
Yes, please.
After they were received by NTA, in what custody they were preserved? When did NTA send them to the State Bank of India and Canara Bank into different cities?
In between, printing is there, miss.
Right.
Printing press. So when are they sent to the printing press?
Which is a printing press?
Yes, please. We will get the details.
We want to know which is the printing press.
Yes, please.
When did you send these question papers to the printing press?
Yes, please.
What were the transportation arrangements made for sending them to the printing press?
Yes, please.
When did the printing press, after the printing press prints them, we are now talking of 24 lakhs, 50 lakh sets.
Yes.
Right? Because 24 lakh had, how many sets were printed?
Correct.
And after they were printed, where were they sent? Are they sent back to the headquarters at Delhi?
Yes, please.
Huh?
The remaining sheets,
No.
unutilized ones.
No. After the question paper is set, it is sent for printing.
Yes.
You have a printing press A.
Yes.
You need not tell us where the printing press is, otherwise next year they will go to that press.
It's there.
Now, it is sent to that printing press.
Yes, please.
Right? How is it sent to the printing press? Under what custody?
Yes.
Second, after they are printed, how do the printing press send it back to NTA? Between that date and give us that date, how many days had elapsed between that and the distribution of the question papers to these 471 cities and 4,750 centers?
The entire moment minutes I'll prepare a tag. Starting from the preparation of the question paper.
See, I'll tell you why we are asking. If we come to the conclusion that the time lag between the leak and the actual date of the examination is relatively limited, then that would be a circumstance which would militate against holding a retest.
Not sure.
If the time lag between the leak and the actual examination, Brother Mishra actually mentioned, is wider, then there's a greater chance that the malaise is across the system.
I get it, minutes, I'll give you time.
If it appears that the question papers were leaked on the morning of the 5th, exam was scheduled at 2 o'clock, students were made to memorize the questions, that may be one indicator that the leak was not as widespread. Somebody who has a question paper is not going to ask students to sit down and memorize them and give on the spot memorize them. How many answers can a student memorize?
There are two aspects to it.
Therefore, we have to have some clarity on facts for us to understand whether this is so systemic that we must order a retest. See, there are 2 or 3 considerations which way. One, if the sanctity of the examination has been lost, then a retest has to be ordered, right?
Yeah.
If we are not able to identify candidates who are guilty of wrongdoing, a retest has to be ordered. If you can't distinguish the grain from the chaff, that is the tainted from the untainted, a retest has to be ordered.
Your Lordship,
on the other hand, right? On the other hand, we are dealing with now a situation of 23 lakh students. It may be far-fetched for us to at least presume, unless they point out material to us, that all 23 lakh students or a substantial number of them are involved in the fraud. For what we know, a large number of students may be just honest students who have appeared for the exam.
Large number are honest.
Therefore, we have to see if, second, what was the modality? One more very important aspect.
Yes,
What was the modality in which the leak was detected? If the leak took place, if the modality of the leak is through electronic means, social media, then there is a possibility that the leak is extremely wide.
Well, that is the point. What your Lordship said is all correct.
Just one second.
The electronic media.
We are flagging these issues. We want you to therefore give us a comprehensive analysis of dates.
Certainly.
Because if the leak is taking place through, say, Telegram, if it is taken through WhatsApp,
that happens.
Because if it's through a social media or any electronic means of communication, it spreads like wildfire.
Yes.
On the other hand, we must also balance it out about the time at which the leak takes place. If it's more or less in the morning of the 5th, then the time between when the leak takes place and the students have to go for the examination is very limited.
On the time, this is a hard decision, but there is
one more thing in which we require some assistance from both sides. Please don't treat it as an adversarial litigation. For the reason that whatever view we ultimately take, this view is impacting the lives of 23 lakh students. Second, we want to understand, is it possible for the court to identify red flags? So, can we identify, either we do it or we appoint an expert committee to identify the red flags? I'll give you some examples of red flags. 720 out of 720. Alright, everybody out of who gets 720 is not a fraudster. There may be still people who are extraordinarily bright, that's 720 out of 720. But we found that for the previous years, the proportion was very low. Now, this year suddenly it goes up to 67. How many out of those 720 are people from that 1563 who are beneficiaries of the added grace mark.
We have given the details in our counter affidavit.
No.
80 places.
No, we just want you to now put it down on a piece of paper for us. Second, we want to understand this. So, a change in centers is possible, right? A change in centers is possible. Suppose a student, I was just telling my brothers at lunch, suppose a student is registered at Lucknow. Suddenly you find that student has gone from Lucknow to a distant center therapy and gets the 720. Suppose somebody is registered in Ahmedabad and suddenly goes to a fairly distant. So that may be one example. So we can, we will have to do some, if we have to separate the grain from the chaff, we will have to identify certain red flags. That those who fall in that red flag category, we may have to then hold a limited retest for that category alone. Second, is it possible to do, using the cyber forensic unit of, say, the Ministry of Home Affairs or whatever, is it possible to do a data analytics on the entire result and to identify? Now, there may be one category I was thinking, when we were reflecting on this matter, students who get exceptionally high marks in the NEET, but whose performance is not reflected in the 12th. But there again, I'll tell you one thing. 1 second. There again, there's a problem. Students don't study as hard for the 12th as they study for the NEET.
Only one figure may assess your lordship.
Another red flag. Another red flag. A student gets exceptionally high marks in one faculty of science, like say physics or chemistry, but gets 5 marks in the others. So, because it may be unlikely that a student who is doing so brilliantly in one would not have studied at all for the other faculty. So the only point is that, I'm not sure whether we should be doing this or whether these wouldn't.
They have not declared the entire result also.
But
as Brother Mishra says, does the full marks have a pattern? We also
I wanted to answer that.
We also want to understand the pattern of NEET itself.
Well, it's the pattern quickly.
Only a minute.
45 questions on physics, 45 questions on chemistry, 45 on zoology and botany. Totally 180. 4 marks.
So 45 questions on physics,
45 on chemistry, 45 on maths, on botany, and 45 on zoology.
So 45 times 4, that is
180. 180 into 4, 720.
Correct.
If you get a wrong answer, -1. So therefore, if you had given 179 right answers, your score would have been 720 minus 5, that is 750. Here, there have been answers, scores of 718, 790. It's mathematically impossible. Because you lose your answer was, that it is because of the grace marks.
But no, I have to read this. Give me 2 minutes, give me 2 minutes.
Submission something.
One just some figures which are handy, and that might answer. I'm obliged, your lordship's question. It's a very pertinent question. We examine the pattern of 100 top-ranking students, those who are in the first 100. But the analysis comes that they were distributed amongst 95 centers in 56 cities in 18 states or union territories. The top 100, they are not found that they appeared in 95 centers located in 56 cities, which are spread out in 18 states or union territories. Is interesting. And my lord,
one second.
Now, page 86 of my reply, but page 37 is the
One more thing which we want to know now is that how many FIRs matters been handed over to CBI for investigation?
I'll just tell you.
Totally, how many FIRs have been registered?
One FIR was paper leak in Patna. The rest, my lord, are FIRs for some local malpractice.
How many totally FIRs have been registered?
According to them, 6. Our knowledge is not 6.
Can you give us tomorrow, maybe
day afternoon, day morning, but we'll be able to have enough.
Just 1 second. All right.
I will tell you.
Second, we want to know, now, one thing is very clear, that the leak has taken place.
In one center.
No, whether one center, that's what we have to decide. The fact that the sanctity of the examination is now compromised is beyond doubt. That there has been a leak.
Yes, sir. I'm sorry.
Now, question is, Mr. Solicitor, how widespread is that breach?
Patna also, the paper leak is not an admitted fact. But my learned friend relied upon that press not kind of a thing.
No, it's an admitted fact. It's later in the affidavit, Mr. Adumara, 1 second.
Yes.
But can we deny the fact that a leak of question papers?
Yes, Lord. Yes, Lord. The complete cover of it is admitted. Bihar police, on that very day on which, my lord, some news reporting came, which my learned friend, my lord, Bishop Huda read. Lord, we issued this press that this is false. This is not our briefing to the media.
No, but it's the case of NTA today that there is no leak.
It's not every style.
The leak is admitted. The fact is admitted and they come after it. Mr. Solicitor, Mr. Quashing, we take it that it's an admitted fact that there is a leak. There is no question about it. But, you know, the nature of the leak is what we are determining.
Yes,
we are asking question. The fact that there was a leakage of question papers cannot be disputed. Now, what is the consequence of that leak would depend upon the extensive nature of that leak. If it was not explained leak or uncontained, I'll tell you one thing. You don't cancel a whole examination merely because 2 students have committed a malpractice. Likewise, assuming that there is a leak, we don't live in an ideal world. There should be no leak. But before we decide to order a retest, we must be careful about what is the nature of that leak, because we are conscious of the fact that we are dealing with the careers of 23 lakhs.
Absolutely right.
And asking 23 lakh students to reapply for an examination, together with the preparation, cost, travel, and dislocation of admission schedules.
Unfortunately, there is no other choice. Unfortunately, there is no other choice. Paper has been leaked.
Now, therefore, we want to know this. Therefore, we would like to know first the entire process which takes place. Two, what is the nature of the FIRs which have come forth? How was the leak? What is the point of time at which the leak took place? How was the leak disseminated? These are important questions. And next, very important, what are the actions which the Government of India and NTA have taken to identify the wrongdoing students or the beneficiaries of the wrongdoing?
Correct. Yes, now I appear for someone who was come first.
I'd like to make submission.
Sir,
I'm in 31.9, my lord.
we have understood your lordship's question. You know, they are very pertinent question, and that would ultimately lead. But I'll just give an example.
One second, Mr. Solicitor, we also want to know what are the steps which have been taken by the NTA and by the government to identify the beneficiaries of the leaks, because that we have to be ruthless on identifying the beneficiaries.
We also have to be ruthless,
right? Because anybody who has breached the examination is not entitled to be there as a successful student.
Those who are identified, their results are. But give me an example.
How many? We want to know how many have been identified.
Yes.
But more than how many have been identified, we want to know what was the course of action which was taken by the government.
So kindly allow me to give an example. But for the time being, leave Bihar. I'll not call the police also. I'll not take instructions. Take for example Godhra. Godhra incident, it passes on as a paper leak case. It's not a paper leak case. What happened was, there was one superintendent of one particular center called Jai Jalaram School. His name is Tushar Bhatt. But he arranged with certain students that he didn't have the paper. But he said that whatever answers you can confidently answer, you give the answers. These are multiple choice questions with negative marking. And therefore, I would have a window of 3 hours before, after I take your papers back, and I seal it and send it to the concerned authority. Fortunately, the authorities, the district magistrate came to know about this. It must have percolated from somewhere. Therefore, the moment examination started, the entire district administration and entire police administration was there. The papers after the examination were taken in their custody, sealed in their presence and sent, and that man was arrested. Now, from his mobile, there were several video chats which were found. And we could identify that these were the people with whom he was in touch. So those identified students, their papers are, their results are with him. And they are issued show cause notices. Why should they not be?
We are not complaining. I am only about paper leakage, partner. Nothing else. All others are minor issues. All are minor issues. Nobody will ask for a cancel of the examination on some basis of that.
Overall, in the entire country, how many students whose results have been withheld, owing to what we are discussing today? Individual, one student cheating from another student, we are not bothered about that.
Absolutely.
And the law will take its own course.
Yes.
How many students are there whose results have been withheld as a